I just pushed the button.
Thank you. Let me know when we're ready. We're ready.
You need to leave your mic off.
I'm going to leave that off.
We're live, Mr. Chairman.
Okay, thank you very much. Good morning, everyone. I'll call the meeting to order. I just want to recognize the committee's work of yesterday. Really appreciate all the work that was done. Good job by the co-chairman of parading that through, and gosh, got done early in time for a cocktail hour after that final bill. So
Can't get it delivered to your door though.
yeah, there we go. So
Aaron.
Katie, or Ted, I don't know that we need to take roll on the second day. So I think that we're all set to go. Mr. Co-Chairman, any comments to start the morning?
No, just really good job to everybody, and hopefully things keep on trucking. We've got another full dish ahead of us. Lots of work to be done, and hopefully by the end of the day we'll have some more bills for session and maybe kill some.
Thank you, Mr. Co-Chairman. We committee will look into the Secretary of State's office work that has been carried out throughout the interim. We also have boards and commissions today, some other committee legislation. So we've got a busy day ahead, and we're going to launch right into it. The Secretary of State's office, we've got folks here with us this morning, and I'm going to ask Ted if you would first, let's bring up 126 version 0.5 revised uniform law on notarial acts. And Mr. Hewitt, are you going to walk us through a little bit, or are we going to turn that over to the Secretary of State's office?
Mr. Chairman, Ted Hewitt with the LSO. You can certainly turn over to the Secretary of State's office if you'd like. I can run through the amendments that the committee made from September if you'd like. This bill draft is actually a bill draft of David Hopkinson's. He went through the draft of the committee in September, but unfortunately he had a family emergency come up over the weekend, and he cannot be here with the committee this week. But I can run through the amendments that the committee made from September.
Mr. Hewitt, before you do that, we do want to acknowledge Mr. Hopkinson, and I know that all on the committee send our very best wishes to him. Sorry for what he's going through with his family. But thank you, Ted. If you want to walk us through those changes that we requested in the September meeting, and then we'll go to the Secretary of State for a little deeper dive. Thank you.
Sure thing, Mr. Chairman. So this is 21 LSO 126 working draft 0.5, and it creates the Wyoming revised uniform law on notarial acts and allows for remote online notarization and remote ink notarization. So the first changes the committee made were to remove 3 new criminal penalties in the prior draft. And on page 2 of the draft, you'll see a staff comment. And that staff comment includes the language of those 3 violations and also includes potentially applicable existing criminal law that might apply in lieu of those violations. So the first of these 3 violations is on page 2. And I guess it's starting line 16. You can see that proposed language. And what the committee removed is a criminal violation of acting as or impersonating a notary when not a notary. And the potentially applicable existing violation is usurpation of a public servant, and that's in WS 6-5-307, and that's a misdemeanor. The next violation the committee removed is unlawfully possessing or using a notarial officer's journal, stamp, electronic signature, or paper or records. And on page 3, you'll see existing violations for theft and forgery that might apply to such action. And then on page 4, the violation the committee removed is for a notary to willfully violate their legal obligations. And potentially applicable existing criminal violations include official misconduct under 65107A and certain misconduct by a notarial officer under 65114. And so with that, Mr. Chairman, I'll pause and see if there are any questions on these criminal violations that the committee removed and potentially applicable existing criminal violations.
Mr. Co-Chairman.
Yep, thank you, Mr. Chairman. Mr. Hewitt, was there any research done in regards to, I remember how we had removed those provisions during the last committee meeting. But I was wondering, was there any research done in regards to what that looks like in other states? Will Wyoming stand alone in this regard, or are we pretty much the only ones mandating stamps?
Mr. Hewitt?
Mr. Chairman, Mr. Co-Chairman, I do not know if that research was conducted or not. I don't believe it was, but I can certainly look more into that. Certainly we could have information ready for the committee come session if this bill draft moves to the session.
Follow up, Mr. Co-Chairman?
No, sir. Thank you.
Committee, any other questions to this point in the bill? Okay, Mr. Hewitt, please continue.
Oh, you're muted.
Thank you very much, Mr. Chairman. Just two other quick amendments the committee made in September. First, it reduced the time required for a notary public to maintain a journal and audiovisual recordings of remote notarizations from 10 years down to 2 years. And the committee made this amendment in two places. You can see on page 53, lines 7 and 8, 10 years was taken down to 2 years. And on page 57, lines 14 to 16, the same change of 10 years, 2 years. And then finally, the committee removed the requirement for a notary public to maintain a $10,000 surety bond. And those are the amendments from September.
Okay, Mr. Hewitt, thank you. Committee, anything for Mr. Hewitt before we go to the Secretary of State's office? Okay, let's do a little deeper dive and a little bit of a reminder on what this bill is all about. Morning, ladies. Nice to have you here this morning.
Good morning, Mr. Chairman. Nice to see you. Good morning, committee.
Thank you.
Kelly James, Compliance Director, Wyoming Secretary of State's Office. I also have with me today our notary officer. This is Carissa Corsi. And we thank you for the opportunity to talk about notary law. As a reminder, we wanted to originally bring this to you next year in 2021. But with the pandemic and everything that escalated, we wanted to get the remote online notarization, the remote ink notarizations in the statutes to help our constituents.
Mr. Chairman, if I could.
Mr. Co-Chairman.
Yeah, thank you, Mr. Chairman. I did want to mention to the committee and for those listening that was such a big lift by the Secretary of State's office that when this whole, it's something that a lot of folks don't think about. I certainly did. When this whole thing broke out, we still have to continue on with life, and the Secretary of State's office did the big lift of putting in place remote online notarization via emergency rule. I think you guys did it within a couple of weeks too. It was a huge lift, and so really, I guess a big attaboy for you guys in your office, because that tremendously helped the state of Wyoming and our businesses somewhat come back quicker because of that ability. So that was a big lift, and this bill is a kind of a reflection of just a small amount of this is just a small amount of the work that they accomplished in a very short time period. So it was a big deal.
Very well stated, Mr. Co-Chairman, and I hope you'll pass that along to the entire crew. You did a terrific job, and just the depth and breadth of this bill alone, let alone all of the work that you did over the past 6 or 8 months on all other fronts. So very well stated, Mr. Co-Chairman. And so let's do a little deeper dive into what precipitated, what caused, what the result was, and what this bill is all about, okay? Just to remind us all. Thank you.
Thank you,
Kelly.
Mr. Chairman, and thank you, Mr. Co-Chair, for your words. Yes, Mr. Chairman, notary laws are found in two places. They're found under two different titles. And so we've always wanted to combine them together and adopt the revised Uniform Law on Notarial Acts. We do have Uniform Law on Notarial Acts currently under Title 34, but it has since been revised. And so we wanted to update it and update all the commissioning processes that go along with it. Like Mr. Co-Chair said, we did issue emergency order to allow for Ron temporarily. We have since extended that through the end of the year, and we will extend it again, hopefully till when this law becomes effective is our goal, just to make it seamless. We have encountered some issues with our emergency guidance. For example, it does seem to be expensive, and it does seem to be timely for the notary to do it. And so we started looking at what other states do and what can we do to help our stakeholders. We talked to many organizations, our county clerks, our Business Alliance, the Bar Association. We talked to the realtors and the insurance agents and the Bankers Association, and we got feedback from all of them. And really, that is when we kind of started to open it up more to just the traditional remote online notarization platform. We wanted to look at other ways where the notary could have that simultaneous audio-visual recording so that they could perform the notarial act. And there's really two big changes from Rulona that we put into our statute, and a huge thank you to David Hopkinson as well. He spent hours drafting this with us, and his feedback was just phenomenal, and we sure appreciate that. And just to give you an update on some of the feedback that we have got since, I have sent the new version out to all of our stakeholders, and we did get a couple of comments. I'll just go over those with you here now. We did get some feedback regarding the fee going up. It is increasing from $30 to $60, but it's important to remember that the term is also going up.
Can you say that again, Kelly?
Certainly.
Which app was that?
That's for the notary fee for the commission.
Okay.
The commission that's filed with our office, that will be going up from $30 to $60. But like I said, it is important to remember that the term is also going up. It's going up from 4 years to 6 years. And because the bond has now been eliminated, the notary will actually be saving money. They typically have to pay a $50 premium for a 5-year bond, and they also have to pay the $18 recording fee with the county clerk. So a $98 for that 4-year term, whereas now we're giving them a 6-year term for $60.
Mr. Chairman.
Mr. Co-Chairman.
Yeah, thank you, Mr. Chairman. Ms. Janes, in regards to the fee going up, that's a 100% increase, and yet we're only extending the timeline by 2 years for them. Would it be possible to either jump that to an 8-year term or to reduce the fee somewhat down to, say, $50?
Kelly, why 6?
Mr. Chairman, Mr. Co-Chair, we looked at what other states did, and we just thought, we're going to go right in the middle. We did do 6 because we thought it's an increase for them, less burden for them to have to refile it with us and get a new stamp and get everything that they have to do. It is, like I said, currently under current law, it's $98 for 4 years, which is $24.50 a year. And now we're going to $10 a year. So we felt like that was a fair number, but that's certainly a policy decision if you decide differently.
Follow-up?
Yes, please. Thank you, Mr. Chairman. Ms. Janes, in regards to the cost to your agency, as far as what that fee covers, what is the total cost incurred by the Secretary of State per application? And is the state, is this a little bit of a retail end where we can cover some of the incidentals that end up happening? Can you explain that, please?
Mr. Chairman, Mr. Co-Chair, that's a great question, and I don't know the exact number. I can tell you that notary applications, I showed you at our meeting in May. You might recall the PowerPoint that had the 9-step process where we have to file the application, we process, we send them the receipt, we send them the letter telling them what to do next. We send the clerk the certificate and the bond notice, and then the notary has to go to the clerk to file their bond. Then we get the bond notice back from the clerk, and so it's quite the process. It was timely. When we hit significant budget cuts earlier in the summer, we did commit to cutting our mailings to all notaries. So we are now collecting email addresses from every single notary, and we are emailing them their letter, which right now does add an extra step. But when this law goes into effect, it will streamline. We won't have that bond step. So we won't have to send the clerk the certificate. We can actually issue the certificate directly to the notary. So I hope that kind of answers your question. It is costly, and I hope that with all this, it will certainly make the process more efficient and more streamlined.
Yeah, just one more.
So go ahead, Mr. Co-Chairman.
Yeah, thank you, Mr. Chairman. And Ms. Jeans, it certainly helps explain quite a bit. I mean, when we look at different for example, for driver's licenses, we recently made a change to the cost of driver's licenses in the state of Wyoming. I think it was like 2 years ago or something like that, where we bumped it from $35 up to $40 or something like that.
Mr. Chairman, we try to do that every 35, 40 years.
Yeah.
Chance we get.
Right. Well, we ended up having to do it because it was actually costing us more to produce the driver's license than what the average citizen was paying for. So we just tried to cover the cost. And so that would be my concern here in this situation. We're actually reducing the amount of work done by the Secretary of State's office, which is great, making government more efficient and lean. That's the role of the day. But then we're really raising the cost, and I'm having I don't think it's that much. I mean, it's $60 for 6 years. It's pretty minimal, but I still got to justify that in my own mind as far as moving forward. So it may be something for the committee to think about, or Ms. Janes, maybe if your staff are listening in that are remote right now, we could find out what exactly is all being paid for.
Ms. James, the other thing is that the co-chairman is on track with one side of the coin. The flip side of the coin, I could ask you this too, which is, are those fees high enough? We probably won't revisit this for a long time. And given the climate that we're in, I'm sure there was some conversations about that. Maybe you could share not just the bottom end, but the top end. What was the conversation in that regard? We have to be cognizant of the fact that a lot of times our fee structure is lagging way behind in terms of trying to help us provide the services to our state. So any thoughts on that front?
Mr. Chairman and Mr. Co-Chair, absolutely. We did research that, and we actually found fee in all 50 states. I believe it ranges from, I want to say in Connecticut, it's up to $100, and it's $40, $30, but the average was around $50 to $60. And again, I think our conversations in our office was really that under current law, they are paying more than they are now. And so we are actually saving notaries $14.50 or $14 every year. And so that's kind of how we landed on that number. We'd be happy to dive into it a little bit more before session, just so we can have some more research for you on how much it actually does cost us to produce those certificates and send those out, and our time and everything like that. But that is where we landed, and that's why we did what we did.
I don't think that's a bad thing at all. If you, the more that you can provide to us as we go forward, but I appreciate those thoughts and appreciate all the work you did to get to this point. And so please continue. Thanks.
Thank you.
Mr. Chairman.
Oh, Representative Duncan.
Thank you, Mr. Chairman. On that subject as well, I don't know if you know this or not, but curious as to whether you know the breakdown of majority of notaries. Are the bulk of the notaries coming from businesses paying for them versus individuals doing this on their own? Do you have any statistics on that at all?
Ms. Jane?
Mr. Chairman, Representative Duncan, thank you for the question. We think it's about half. Processing notaries, you'll see of course, the payment that comes through. We do accept cash money order or a check at this time. We don't accept credit cards for notaries. So you do see the check, and half of the time it is the employer that is paying for it. It's hard to say if the employee has to pay the employer back for that, because they keep that notary with them if they leave their employment. So, but I would say half of the employers pay for it.
Quick.
Okay, follow up, go ahead.
Thank you,
Representative.
Mr. Chairman. But we don't know for sure, because people like me, who the business paid for it, but it was out of my own.
You are the business.
I am the business. So so it could be higher.
Certainly,
Okay,
Mr. Chairman. Yes.
thank you.
Okay, anything else, committee? All right, please continue.
Mr. Chairman, we also just heard, regarding the elimination of the bond, just that from the insurance side, that some, we're slightly concerned about that, but most, it sounded like we're fine with it. It's a process. When we spoke to the Association of Wyoming Insurance Agents, they talked about the stack of papers that they have to do and the small sliver of premium that they keep for themselves. And so really there was not a lot of issue regarding the elimination of the bond. We also spoke with First American Title regarding a letter that was sent to Senator Nethercott in the September meeting. And we discussed their concerns. I believe they are here to testify today to you. And so there may be some things that we may want to clarify further at the end of public comment, if that's possible. We would appreciate the opportunity to follow up with them. But we did have a great discussion with them, and we certainly understand title companies and mortgages and their needs. And truly our two big changes that we did when we drafted this with LSO is really, we took Rulona and we wanted to make it a little bit easier to read. So we took the remote section, which Rulona was designed so that you can either adopt it with RON or without RON. And so we wanted to incorporate RON into the entire statute, so you wouldn't be pulling places and trying to figure out how to read it when you go through it. So that was our biggest thing, was reorganizing and combining definitions so that you would only look in one place. For example, under the appearing before and the satisfactory evidence, the whole purpose was that you're just verifying identity. No matter what the notarial act is, whether it's online or it's ink or how you're doing it, that you are going to verify identity, and that's going to be required for every single notarial act, whether it's remote or not. So that was our purpose in doing it, and I know that they'll explain their needs. Our other big change was opening it up to various other forms of technology, communication technology, such as Zoom. That was something we heard from our stakeholders that they wanted. And so that's why we did what we did in the statute, opening it up so that your title companies, your mortgage companies that have to use a platform, that are required to use that security, and that they can, that's an option. But if you have something else, your estate planner who needs to do, a will, somebody that's quarantined, that yes, you can do it by Zoom and get that accomplished as well. So those were our two big changes in Rulona, and I know we'll hear from them and what they need as well. On the amendments, Mr. Chairman, as LSO went over the retention at your last meeting, it was changed for the Notary General and the audiovisual recording from 10 years to 2 years, as you heard. Our ask would be that it is amended again back up to 6 years. And our only reason for that is because that's the term. The notary has a term of 6 years. So it only made sense to us that they should keep those for 6 years, especially now that the bond is eliminated. It just provides more protection for the notary. And Mr. Chairman, on that, we understand that the 10 years is high. That is somewhat the industry standard. And I think you'll hear some testimony that they also would like it to be 10, which we understand. And I believe we went to 2.
So Ms. James, when you say that industry wants it to be 10, are you talking about our notaries out across the state? Is that who you're referencing? And they want to keep records for 10 years?
Mr. Chairman, thank you. By industry, I was referring to First American Title. I know that the title companies wanted it to be 10 years. And it is also the other state's standard as well, is the 10 years for, it's Brulona.
Okay, thank you for that clarification.
Yes. And then, and Mr. Chairman, that again is on page 53, line 8, and page 57, line 15, if you do consider that. We did speak about enforcement, and we certainly understand that it can be found in the criminal code, possibly charged. In our conversations with law enforcement, they have asked us to include it in our statutes. The discussion with them includes, the accessory to the fraud. So the prosecution was having a difficult time charging the notary with an accessory, whereas if it was in the notary law, they could just point to right there and say, here's where the notary committed this crime, we're going to charge them with this. So, Mr. Chairman, it's up to, your committee on your policy decision on enforcement, but that's definitely what we're hearing from our law enforcement. And that's really all I have as far as comments. We sure appreciate your committee taking a look at an 80-page bill, and we'll certainly stand for any questions at this time.
It's kind of ironic. Last week, committee, I was involved in some title work up in the neighborhood of Senator Case, and back and forth a little bit with some folks who are going to be represented here in our public discussion here pretty soon. And it was indicated to me that there is some heartburn. We'll wait and hear from the public, but I hope you two can stick around in case we need to bring you back up or want to and clarify or ask any further questions. Committee, anything for these two before we go to some public comment? Anything else, committee? Oh, Representative Mayor, I'm sorry. I'm getting used to these in-person
I had my
meetings.
camera off and thank you, Mr. Chairman. Ms. James, I realize that this is kind of a standard bill, and I should have brought this up, discussed it earlier. But I was reading through last night, and the term journal appears several times throughout the bill, and it's not in the definitions. I mean, everything in the world is defined, included in definitions, but journal is not. Is there a reason for that, or?
Ms. James, what's a journal?
Yeah,
You mean the notary's journal?
I guess.
I think that's where they record what they do.
But shouldn't it be in the definitions? I mean, everything else in the world is in definitions.
Mr. Chairman.
That's a good question, Representative. So
Yes, Mr. Chairman, Representative, that is a good question. And I believe that we did try to make our definitions pretty robust because we wanted to make sure you can go and find, so that it's possible that was an oversight, and we can look and see. I know I know it's discussed in the section about journal. Yes, on page 53, on line 18, it talks about how it's maintained. A tangible medium shall be permanent, bound, register with consecutive numbered pages designed to deter fraud. So it's very specific in the section on it, but to your point that maybe it should be in the definitions, that certainly would make sense to us.
follow-up, Representative? Oh, that's a good question. Honestly, I don't know much about these journals. We have a notary sitting right here that we can maybe visit with about that, and I'm sure some others might clarify, so.
Mr. Chairman, yes, we currently don't have a journal requirement. Most states do. And most notaries do keep a journal. And this is something that we wanted to encourage and put into statute that, yes, you should keep a journal.
I live with one too, committee, so I can make a phone call.
A journal or a notary?
I live with a journal. No, I live with a notary. Representative Duncan.
Thank you, Mr. Chairman. If you would indulge me, it's just a simple little book that you can buy at any stationery store or anything. And it's just, it's got lines on it and it has the name of who you're going to notarize with. So you put their name, potentially their address and the date, and also sometimes it has a line for you to mark what you're notarizing. Then you ask the notary, the person in front of you, present your ID, and you take a look at it. And some people record their ID number, like their driver's license number and stuff. I personally do not, because I don't want any personal information in my possession. Then after they record who they are seeing in front of them and the date, then they can proceed with their notarization of whatever document it is. It's just a way to document who you saw and notarize what and when.
Thank you for that.
And it doesn't have to be in a book. It could be online. It could be anything. I do a lot of outside notarization.
What was
I do
that?
mainly clients that were already doing a transaction.
Real estate.
So I don't really need a journal because they're already a client with us. So there's not really a necessary. But if I were doing documents that weren't prepared in my office and that weren't privy to us and we didn't know them, I would be definitely doing a journal.
Thank you, Representative. Appreciate it. Ladies, any other thoughts on that?
Other
Representative Eric, follow up.
Well, thank you, Mr. Chairman. Yeah, I don't know, just maybe a comment rather than a question, but as I was reading through, I come across the term journal several times. I thought I knew what a journal was. Pretty well understood that, but I thought, well, I'll go back to the definitions and find out for sure. I couldn't find it there. So I think it would be good to include it in our definitions.
Definitely.
Well, I think, I'm not sure when one has ever been referenced. Ladies, maybe you can help us with that. I guess some would probably keep better journals than others. And this is a pretty good descriptor of what we expect, but yeah, I think it's a good question. Is it a yellow pad? Is it wide ruled or college ruled? You know, anyway. Well, thank you very much, you two. And
Mr. Chairman, you've got a bunch more questions. Jim Blackburn has
Representative Blackburn, thank you. I've been trying to watch the screen and learning this in-person stuff committee. So Representative Blackburn first.
Thank you.
I think Senator Nethercott had a question.
I also had read this bill several times, and I think on going back to page 53, it talks about an electronic journal, so we could do it on the computer. And as Representative Duncan had pointed out, line 10 on page 53 talks about the notary public shall maintain one or more in which the notary public will write down all the notary acts that they perform. So I think it's pretty well spelled out. I don't know if we need a journal that says, well, it's leather bound or whatever, but just my thoughts. I was a notary at one point. We did have a journal and we wanted to have that big leather bound one. So that's what we did. So thank you.
Thank you, Representative. Senator Nethercott, did you have something?
Your Honor, I think.
You're not in your hearing anymore.
Switch.
One of the nicest things anybody's ever said to me, though.
You sure?
Yeah, you're real sure about that.
Yeah, well, maybe.
Here we go. You know, they keep a tally of how often I say that. Mr. Chairman, my biggest concern, though, is when I call Your Honor Mr. Chairman. That will be the day. Representative Aird identified, I think, an important distinction, but I do think that the concept of the definition is located within the statute itself, as Representative Blackburn adeptly pointed out. And it's also, I think, located within the rules too for the Secretary of State. my primary concern with this is making sure as part of that journal entry is that really, I think the proof for the notary is going to be in what form of identification was taken. That really is the greatest level of defense. So the purpose of that journal is to really protect the notary from allegations of fraud, for them to be able to go back and say, well, I did see their driver's license. They did appear in front of me. Here's their driver's license number. And certainly, of course, that can be abused. But generally speaking, this is one of those safety measures that's not too burdensome to protect the public. So Representative Ayer, I think, makes a good point that there's that clear definition isn't there, but I think there's that clear delineation of all of those concepts that are supposed to be included in that journal entry. So I don't know that it's necessary.
Thank you, Senator. Anything else, committee, before we allow the Secretary of State's office to retreat a little bit? And we would, so Mr. Co-Chairman.
Yeah, thank you, Mr. Chairman. Ms. Janes, in regards to the requirement for the 2-year and asking to bump that up to 6-year, you testified that the reason why we should go down that road is most states are right around 10 years, and the title firms out there wanted a little bit higher. But if everything in regards to this timeline, to me, points at it for a specific purpose. And you know me, I don't really care much what another state wants or does, or nor do I really care what an existing industry wants, because technically, in my opinion, most of the time they're mandating or wanting something like that to help keep out competition. So all of that aside, why should we move that up? Is it for the purposes of law enforcement? Is there so many years in regards to notarial acts that somebody could be tried in that regard? Is there criminal issues here?
Ms. James?
Mr. Chairman, Mr. Co-Chair, it's really just about protecting the notary. Having that journal for your entire term just would ensure that you could go back and say that I did check satisfactory evidence on this notarial act, and I can prove it. I can show you where and what I got and what I did for my entire term. And to speak to your second question, I'm not sure. I believe that fraud may be 4 years. I don't know for sure on that, but really, we just wanted to protect our notaries, and I would think that most notaries would keep it for the entire term anyway, but that was just our goal.
Follow-up?
Yeah, thank you, Mr. Chairman. Yeah, and so that, I mean, if you look on page 53 under subsection 3, it specifically cites the reason for it is be examined by a law enforcement officer in the course of an official investigation subpoenaed by court order or surrendered at the direction of the Secretary of State. So if we're looking at fraud and the limitation on fraud is 4 years, that would make sense to me at that point. But I do think you're right. I think most notaries are probably just going to say, well, why would I just delete this automatically? I mean, hell, I've got stuff from 20 years ago that I keep just because I'm lazy. Not because I should actually get rid of that shit. So maybe 4 years, I think, would be more appropriate if that is the statute of limitations. But maybe, I don't know if Senator Nethercott, she's kind of the judiciary chair, maybe she'd jump in on that.
You know, Mr. Co-Chairman, I was going to consider checking with my attorney. So Senator Nethercott, any thoughts about the protection that might provide to a notary or anything else in that regard?
Mr. Chairman, it is the first line of defense for a notary, right? I mean, so that the record speaks for itself. There's no statute of limitations for crimes in Wyoming. So anyone can be prosecuted for fraud, whether it happened 50 years ago or yesterday. There are civil statute of limitations associated with a civil wrong for fraud, but I think we're talking about the criminal piece.
What is the limitation on the civil?
What are the limitations on, I'm trying to get the words around.
Civil?
Yeah, so what are the limitations on civil, Senator? I mean, I'm sorry, I'm riding a slower horse this morning.
Mr. Chairman, thank you. I think an argument could be made that it depends on the basis for the underlying fraud. So if it was a fraud based in contract, potentially, if it's a written contract, that would be for a period of 10 years. If it is more of an intentional tort-like crime, that would be a 1-year period for a civil remedy or a wrong. And there are some variations in there, but I think the longest civil statute of limitations that may apply would be 10, and the shortest would be 1.
Thank you for that.
$100, please.
That's it? Jared charges me a lot more than that.
There we go. All right, committee, anything else? Anything else for the Secretary of State?
Mr. Chairman, I don't know why I had 4 years in my head. Maybe it was something civil, but yes, to the co-chair, and thank you to Senator Nethercott for that. But to the co-chair's question about law enforcement, we do get requests from them to contact information for the notary so that they can inspect their journal if they have one. And so this, again, would just put that requirement in there that they would have to have one, and that would help our law enforcement be able to look at those crimes.
Thank you, Ms. James. You know, I really was honestly going to ask you what sorts of heartburn are coming out of the title companies, because I did run into that last week. But I'm going to save that because we do have some public comment that we can go to and then maybe bring you two back. So anything else before you go?
No, thank you, Mr. Chairman.
Committee, one more shot at the ladies from the Secretary of State's office. Okay. We're going to go to public comment. Do we have anybody in the waiting room?
Yes, Mr. Chairman, we do. They're all in the room now.
Let's go to public comment of those who are here at the meeting this morning.
Scott Meyer. Scott Meyer.
Scott Meyer is Scott. Let's go to, Scott must be on,
He's in.
Zoom this morning.
Yep.
So let's start with Scott if he is available.
Here, Mr. Chairman.
Go ahead, Mr. Meyer. Good morning.
Thank you, Mr. Chairman, members of the committee, Scott Meyer with the Wyoming Bankers Association. I will tell you that generally speaking, my members are in support of the efforts that the Secretary of State's office have taken and like to see, some improvements into this statute. But I think there's a couple of concerns that are out there, just kind of listening to what was being mentioned out here in the discussion. But I guess generally there was some discussion about the journal and the protection of the notary. And most of my members, of course, have notaries in the banks, but the general rule is that they don't notarize anything for somebody that is not a customer. So they know who their people are. And so I guess the thought really is that while you may have some ideas that we're going to put this journal together so that we can protect the notary, I think the general comment that I'm getting back is, why don't you let the notary worry about that? If they want to keep a journal, they can. But they don't necessarily have to. And that is primarily because I think a lot of banks don't require their notaries in their offices and their banks and stuff to keep the log for the journal, because frankly, they know who everybody is that they're doing it. They just don't do it for somebody that's not a customer. And I think other than that, the general comment that we thought was that, and maybe it's the difference between campaigning and lawmaking, but there's a lot of conversations out there about reducing regulation and reducing all the government oversight. And this bill does exactly the opposite of it. I think that there is definitely some need to have some changes in the statute on how we do stuff, especially in the remote area. But I do think that the members that I have that have expressed their viewpoints think that at some point in time, we're getting just a little bit overreaching on some of this and start to dictate on how they do things and why they do things. And I think the journal is just an example of that. That's all my comments, Mr. Chairman, and I'm certainly willing to stand for any questions.
Committee, any questions for the Bankers Association this morning? Any questions? Senator Nethercott.
Thank you, Mr. Chairman. Mr. Meyer, I recognize in your role as representing the banking industry as a lobbyist isn't the same as representing them as a lawyer, but would it be your advice to the banks to use a journal if you were representing them as a lawyer?
Mr. Meyer.
Mr. Chairman, Senator Nethercott, not only am I with the Wyoming Bankers, but I am an attorney with a notary stamp, and I do use that. And my advice would be that if that it would be definitely something that they may want to consider doing to make sure that they have all their bases covered. I think that the rub just only comes in as a requirement by law.
Okay, follow up.
Chairman, I won't charge her $100 for that comment.
I do have a follow-up, Mr. Chairman. Mr. Meyer, isn't it true that most of these notaries public don't have the benefit of a Juris Doctorate, but instead are really more of your entry-level employees?
Mr. Meyer.
Mr. Chairman, Senator Nethercott, I don't know exactly who is doing the notaries at the various banks. I could not answer that.
Follow-up, Mr. Chairman?
Continue, Senator.
Just because it's a fair fight. Mr. Meyer, isn't it true that if the notary is accused of participating in an act of fraud, that would not be covered by the bank's insurance?
Mr. Meyer.
Chairman, Senator Nethercott, I don't know. That's a leading question, and I'm not sure exactly how to.
I don't know whether to sustain that objection or, go ahead, Senator.
Yes, Your Honor.
I'll leave the rest for discussion. Thank you, Mr. Chairman.
All right. Thank you, Senator. Anything else for Mr. Meyer this morning? Mr. Co-Chairman.
Thank you, Mr. Chairman. Mr. Meyer, was it the Bankers Association? Was there any concerns in regards to the requirements of the journal as I go through it? There are lots of requirements on how the journal looks, but there's no requirements as far as what type of security is maintained in regards to the technology being used for those recordings. And my concern there would be it's going to be a shotgun effect of different types of technology used throughout all of those different types of notaries. There's going to be people that record it on their iTunes account, and there's going to be people that record it on just on Paint, Microsoft Paint. So the difference is going to be pretty robust. Now, granted, I'm not the type to mandate a certain type of technology is being used, and I tend to agree with you that I think good notaries are just going to keep a journal regardless. Is that a concern of the Bankers Association, that there might be a availability for a process by which somebody could manipulate such data?
So, Mr. Meyer, the language in the bill requires an electronic format to be permanent, tamper evident, et cetera. Is that tight enough? Is what the co-chairman is asking, I think.
Well, Mr. Chairman and Representative Lindholm, I think that we had addressed a little bit of this during our last meeting when we had talked about keeping copies of what have you. And it is a concern, I think, for my members, but it's also a concern, I think, for most other notaries that are out there. I'm just going to guess, but I would think so, that how you keep that information is going to be a matter of discussion at some point in time, because as I mentioned before, I think I got served some discovery with somebody, a month ago, whatever, and had some documents in there, and they were all on a CD drive. And I had to really tell the other attorney, I'm sorry, but I don't have a CD drive in my computer. Most people don't in the new ones. And yet, what if I keep something and I think back how long ago it was that CDs were a big thing, or even, your 5.5-inch floppy disk. I don't know what the medium and what is going to be required in the future that you say, look, I've been keeping this information, but is that even accessible in 5 years or 10 years? And so I know that we've changed that in the statute there. At least there's been an amendment to change that to 2 years. But I really do wonder exactly how you're going to keep all this stuff and what is it going to be. If Representative Lindholm was correct, you do it on iTunes or you do it on Paint or whatever, is that going to be accessible in 2 years or even 5 years or whatever down the road that you think you might need? And so, I guess to that extent, maybe paper and pencil was just the best way to do it because I know I can keep that. But I do think that is a question that a lot of my members have is how do they keep that journal if it's going to be so required?
So, Mr. Meyer, maybe those CDs will come back around like those records, those black things that used to set on a turntable, and they're making a comeback. So you never know. But
You never know, Mr. Chairman, and I will tell you, I have a lot of those black vinyl that now I can play again.
I just, ironically, I just got rid of my 8-track tapes not that long ago. Gave them to some garage sale that was benefiting somebody, hopefully.
Well, probably somebody like Senator Nethercott probably never even saw an 8-track because she's so young.
Yeah, I'm afraid so. Follow up, Mr. Co-Chairman.
Yeah, thank you, Mr. Chairman. And one of the big concerns that I've got is, along with Mr. Meyer's concerns, is how do we even regulate this horse on page 53? If the journal is maintained in an electronic format, it shall be in a permanent tamper-evident electronic format. Doesn't exist. It just flat doesn't exist. 10 years from now, everything that we think is tamper evident will be, I mean, there's no way that we can enforce this. Or at least I can't see a way that the Secretary of State's office could possibly enforce this moving forward. I think I would propose it provides them with an impossible task moving forward as technology advances. And I don't think the Bankers Association is wrong at all to point out that this is a good thing. And I definitely hat tip to the Secretary of State's office for putting something in line that will provide more, maybe more consolation towards the notaries that are out there. It's an impossibility.
Mr. Co-Chairman, it strikes me that that language on page 53 does refer to rules. And one thing about rules is that you can respond a little more quickly to changes in technology or whatever. But you bring up a good point, and that page 53 might need our attention going forward. So anything else, Mr. Co-Chairman? Then I'll go to Representative Duncan.
I guess just in regards to a possible fix, what would, to finish out with Mr. Meyer, what would Mr. Meyer's recommendation be to handle this portion of law in regards to the journal?
Mr. Meyer, any thoughts about how we might store that information or lock it down better or reference it in the green books?
Mr. Chairman and Representative Limholm, I'm not sure how you would do that. I can envision having, I said, like other than pencil and paper, I could envision having an Excel spreadsheet if you're going to do something electronic. Maybe you could have it password protected so other people can't get to it. But I will tell you that I'm not sure how you could make it tamper proof because I could always go in there and go, yeah, let me change that. And short of having something with pencil and paper, and I think also maybe having the person that is getting their documents notarized actually sign the book or whatever, which I know that, my paralegals will do at times, excuse me, that say, here, I need you to sign my book. And so that way that is pretty tamper evident that, or proof because they can show you how in effect they came in, notarized something and made that person sign their book. I think that I would agree with Representative Duncan in that, there may be a place in there where you can record some information like a driver's license, but you would put, they would put in there just verified or something. So they wouldn't put that information in there. But short of having somebody do a signature, I don't know how you would make it tamper proof.
Mr. Meyer, thank you. I want to go to Representative Duncan, then Representative Clausen had his hand up, and then we'll go to Senator Nethercott. So Representative Duncan.
Thank you, Mr. Chairman. So I was 50-50 on this. It didn't really affect me. It doesn't really bother me. But now after hearing testimony and a different debate, I don't like the idea of putting this in statute. Because when we looked at the, just a couple of years ago, when we took the retention of records for real estate, and we took that from 7 years to 2 years, there was a lot of people who really freaked out about that. And the idea was it's a business practice. If your business wants to hold records for longer than 2 years, then you do that. That's your policy. So I see this as the same thing. As a business practice, if you are a notary or like the bank or whoever, you would have your own policies in place and say, okay, well, it's in our business policy, it's in our office policy that we are going to keep and maintain a journal, and whatever that looks like, and maintain it for 10 years or the time, the amount of time you have your notary stamp. That's how I would proceed in my particular office and situation. I don't think we want, as things change, and different things, I don't think we want this in statute. I think it's a matter of, you know, if you're going to be putting yourself out there and you have a taken oath that you're not going to be fraudulent, you know, and you're going to be your due diligence, then you are going to protect yourself by having a journal. That's where I'm at with this. I think after hearing everything, I think it's take it out of statute and allow the businesses or the notary to protect themselves. It's better practice, and it could be in their documentation when you become a notary that these are best practices, but you can't enforce it.
So, yeah, I'm trying to get my head around the notion of any expectation in rules. Do we even want to go that far? And we can talk about that. So thank you, Representative. Representative Clausen, I want to go to you.
Thank you, Mr. Chairman. Just thought maybe on the other side of the bill. So I think we're making this harder than it really needs to be. Sure, there's no perfect technology and everything's going to be newer and better, and we can tamper with what we couldn't tamper with. But I think this is a case of, it's not super sensitive information. It's not something that hackers are going to be after. It's something to kind of protect yourself. And I don't think it's that hard to use current technology to achieve this. And it's not overburdensome. I mean, somewhere down the road, sure, there'll be something better and we can switch to that. But I don't think it's that hard.
Thank you, Representative. Senator Nethercott, and then we'll go to Representative Blackburn.
Thank you, Mr. Chairman. Just as kind of part of this discussion, when I look at page 57, lines 14 through 16, that just only creates a requirement to keep the record regardless of its format for a period of 2 years. So that's not particularly burdensome.
On page 53.
57.
Page 57, line 14, right? Yeah.
57:14. And so as we move forward and understand, you know, really what is being required or asked, I mean, that's it. And that's consistent with the audio record too for the remote authorizations. So, you know, my advice would be to keep it consistent with the statute of limitations for exposure of liability. That's how lawyers keep most of their records. But of course, that's up to the individual decision-making of each business, but a requirement that it stay in place for 2 years. I don't think that's particularly onerous either.
Thank you, Senator. Representative Blackburn.
Thank you, Mr. Chairman. 3 things. Number 1 is I do have a standalone CD player that's the size of a CD that I plug into my little laptop that has no CD player. So that technology is there. That's number 1. Number 2, I don't think this particular law is there just to protect the notary. I think it's there to protect other people as well. Number 3, as I look on page 53, line 22, it's tamper evident, not tamper proof. To me, tamper evident means that, and I could be wrong, we got lawyers, I'm sure Senator Tara Nethercott will let me know, but evident means to me that so that the Secretary of State or someone can see, did that notary change something that was written down? That's all I have. Thank you.
Thank you, Representative. Anything else, committee?
Yeah, Mr. Chairman.
Mr. Co-Chairman, and then we're going to allow Mr. Meyer to weigh in one more time. And
Okay.
Go ahead.
Yeah, no, I think when we think about tamper evident and tamper proof, I know this is going to sound silly, but I think of cattle tags. Because there's certain types of tags out there that are tamper evident, that are mandated by law, that you use, like 840 tags for brucellosis tagging. You can use those, and those are certainly tamper evident. But when we're talking about technology, the reality is we're talking about, when we say tamper evident, we're saying tamper proof also, because at that point you have to be able to prove that you can see every time that that document has been changed. And there is no technology that exists today that can say that forever and ever. It just doesn't flat exist. So
What about
tamper evident
blockchain?
and well, even then, I mean, I'm like the biggest believer in blockchain technology, but I'm a firm believer in also quantum entanglement is coming, and quantum technology is right around the corner, which will make all of it moot.
You all knew that, right? Okay. go ahead.
So my point is, when we do talk about tamper evident, those can be changed. I mean, you can even on a robust system such as Adobe's PDF, where you can actually view when the last time a file was manipulated. I'm not that techie of a guy, and I can change that.
Yeah.
I can make you believe that that thing was changed before Adobe was even a company. And so even with implementations like that, this is the world I mean, this is the time of infinite knowledge, where you know all of man's knowledge at the tip of your fingertips. I really have a hard time putting that in statute.
We will continue that discussion when it comes time and land on a couple of pages with regard to this topic for sure. Mr. Meyer, I want to go to you one more time to kind of sum it up for us from the banker's point of view.
Thank you, Mr. Chairman. I just wanted to throw out one additional comment, and it's based on some comments that were made by the Secretary of State's office and by Senator Nethercott. I'm constantly reminded by some folks in the Secretary of State's office that not everybody does things the way I do them or the way that Senator Nethercott does them, and that there are definitely bad players out there. And so when the subject came up during the testimony about law enforcement, there seems to be, in my mind, a reason for, in certain circumstances, that maybe that journal may make some sense. So my only suggestion is, at this point in time, is maybe consider that if you're holding yourself as a notary public and you're actually notarizing for just about anybody in the public, like, you go to, I know that some of the grocery stores in their customer service area, they'll provide notary services. They don't know who I am from anybody. Maybe in that kind of a circumstance, a journal does make some sense. For those that are, like I say, in banks that do notary services for only their customers, or maybe those lawyers who only do notaries for their clients that they actually know and everybody else. I don't know if there's a way to do that, but maybe that if you're holding yourself out in the public to do notary work for just anybody, that maybe you do have to require a journal, because I recognize that now that there are probably bad players out there that just don't do the rules like Senator Nethercott and I do, that we do follow those things. So.
Thank you, Mr. Meyer. I'm going to go to Mr. Holtzman. Chris Holtzman, I think I see you in the room with us. Chris, if you would like to join us and make a comment or two this morning.
Good morning. Are you able to hear me?
Good morning. I hope I pronounced your name correctly. Is it Holtzman?
Holtzman, yes, Chairman.
Okay, please take it away. Thanks for being here this morning.
Thank you for having me. Chairs Lindenholm and distinguished members of this committee. First American's very grateful for the opportunity to come and speak with you in support of this bill with certain amendments. We thank the committee for its sponsorship of the bill, the Secretary of State's office for all of its efforts in drafting the bill and getting it to the position and place it is right now. And thank Senator Nethercott for the invitation to testify today. As I mentioned, my name is Christopher Holtzman, and I'm a vice president within First American's title insurance company's corporate underwriting department. Over the past 2.5 years, I've spent a significant amount of time reviewing and commenting on legislation and regulations around remote online notarization nationwide. I've also spent a significant amount of time working with our business operations teams and leaders to implement remote online notarization into our practices. So this testimony is really seeking to supplement and provide commentary to the suggested revisions that were submitted to the committee. First Americans' comments can be categorized into 5 categories. The first category relates to the people authorized to perform notarizations for remotely located persons. The bill currently authorizes all notarial officers to perform notarizations for remotely located individuals. First Americans' comment is to limit that authority to perform the notarizations for remotely located individuals to notaries public. I'm just going to take a second to explain the reasoning for that. As drafted, the bill will authorize all notarial officers to perform notarizations for remotely located individuals in accordance with the rules established by the Secretary of State. And the Secretary of State governs notaries public, but not all notarial officers, because notarial officers can include judges, clerks of the court, and deputy clerks of the court, among others. Those notarial officers fall under the judicial branch and are therefore outside of the regulatory regime of the Secretary of State. And so we would recommend limiting the authority to perform notarizations for remotely located individuals to notaries public. I will just mention an alternative approach may be to grant all notarial officers the authority to perform notarizations for remotely located persons, then delegate the authority to establish rules for notaries public to the Secretary of State, and separately delegate authority to establish rules for other notarial officers within the judiciary branch to the Wyoming Supreme Court. The second category relates to the method and mode for notaries to properly identify remotely located individuals. The key distinction between Wyoming's existing notarial law, the key distinction between Wyoming's existing notarial law and the bill pending before this committee is that the bill authorizes notaries to perform notarizations when the person seeking those services is not in the same physical location as the notary. Because the notary is not going to be in the same physical location to review the individual's tangible ID, the bill must both enable and require technologies and practices to detect and deter fraud. Today, the national standard is to require a notary public to identify a remotely located individual using multi-factor authentication. This simply means 2 or more methods of proving one's identity. First Americans' comments address the method of identifying the remotely located individual by revising the definition of satisfactory evidence to account for the various scenarios that could arise. As in today's world, a notary that personally knows the individual seeking the notary services would not be required to complete multi-factor authentication. Similar to in today's world, if the notary personally knows the signer, they're not required to show their ID to prove who they are. But absent personal knowledge, a remotely located individual should be required to successfully complete multi-factor authentication before the notary public is permitted to complete the notarial act. It should not matter whether the form of notarization is remote online notarization or remote ink notarization, nor should it matter whether a traditional remote online notarization platform is used. The key point here is if a person is not in the same physical presence of the notary performing the notarial act, additional safeguards should be required. Otherwise, the bill could create a loophole that fraudsters may seek to exploit. The third category, and there was a lot of discussion on this one, relates to the retention of the audio-video recording of the notarial act and the journaling requirements. The bill currently requires audio-video recording of a notarial act to be created and retained for a period of 2 years. Similarly, the notary must create an entry in an electronic journal to chronicle all the notarial acts performed and must retain the electronic journal for a period of 2 years. First American has requested the time period for the retention of the audio-video recording of the Notarial Act and the retention of the journal be increased to 10 years. First American's comments also request that the notary have the ability to designate a custodian of the audio-video recording in the repository. And this isn't a point that I had made, but it's certainly been discussed at length during this meeting. The statute of limitations period to bring civil lawsuits in Wyoming range anywhere between 4 years for fraud and 10 years for breach of contract. So as a result, it's recommended that the retention period be increased to 10 years so that a record is preserved in the event of a subsequent dispute. The fourth category relates to the real property laws. This bill updates and modernizes the notarial law in Wyoming, and so too must the real property laws be updated and modernized. The bill includes what is commonly known as papering out provisions. That is, a notarial officer may print or supervise the printing of an electronic document into paper format and then certify that paper copy as a true and correct copy of the electronic version. First American has two minor comments related to the papering out provisions. First, the bill does not require that a county recorder accept a papered out document that is otherwise entitled to be recorded. The bill makes it permissive for a county recorder to accept. Second, the bill should include a safe harbor papering out form so that notaries, county recorders, and others know the form to use and will be comfortable relying on a papered out document. Additionally, First American's comments include conforming amendments to 5 sections of the real property law. These changes clarify that documents notarized outside of the physical presence, but in compliance with the bill, or documents that are electronically signed, will still be entitled to be recorded under the real property laws. And if a document is duly recorded containing a defect because the notary or signer made a mistake in notarizing the document, such a document would not be able to be challenged solely on the basis of that defect. And then finally, the fifth category is more of a catch-all and just really relates to 2 technical comments we had. First relates to section 32.3-109, which recognizes foreign notarial acts performed by a notarial officer authorized by a foreign country. This may require an apostille in accordance with the Hague Convention. First American's comment is to add a new subsection to define foreign state that only applies in this recognition statute. The term foreign state is defined within the definition section, but it's defined as a jurisdiction other than the United States. For purposes of recognition of notarial acts, a separate definition of foreign state is appropriate that is a government other than the United States, because the intent of the section relates to recognizing a foreign notarial act. A similar carve-out should be added to the definitions of foreign state, just to clarify. And the second piece to this, and I apologize because this comment was not included in the comments submitted to the committee, is to clarify the official stamp as meeting any requirements for an official seal. This change can be accomplished by a simple revision to the definition of official stamp. The purpose of the change is to clarify that a notary may continue using the notary seal and that the use of the notary seal satisfies any requirements for the notary stamp. And I'll be happy to provide this comment in writing to the committee after this hearing. So with that, I'd like to thank you for the opportunity to provide testimony and support this bill and ask the members of the committee if there are any questions.
Mr. Holtzman, thank you. That was a lot, committee. Any questions of Chris this morning? Any comments? Okay, thank you, Mr. Holtzman. We will take up, appreciate you weighing in on this. I know as we work the bill, these will crop up, and some of these, I would think, Mr. Holtzman, and maybe you can confirm, it seems to me that some of this could be accomplished through rule. You know, with the Secretary of State's office working hand in hand with those of you in your industry. Is that not correct?
Yes, Mr. Chairman, and the Secretary of State's office has been great about meeting and hearing and listening to all of our comments, and we really appreciate Secretary of State's office's efforts.
Okay, committee, if there isn't anything for Mr. Holtzman, we're going to move on. I don't show anybody else who wants to provide public testimony on this. And so with that said, I'm going to bring the Secretary of State's office back up here to allow for any final comments they might have, committee, and then we'll work the bill. Mr. Holtzman, thanks again. Excuse me, Senator Nethercott.
Thank you, Mr. Chairman. I provided a link to the civil statute of limitations listing of all the statute of limitations consistent with what Mr. Holtzman provided. And there is included fraud and then the basis in the contract as well as mentioned. So that is a 4 to 10 year limitation. But for the committee's benefit, that link is there.
Thank you for that, Senator. I appreciate it. Committee, that'll be in your inbox on your emails. Thanks again, Mr. Holtzman. We will, you're welcome to stick around while we get some final comments from the Secretary of State's office. And Kelly or Carissa, take it away.
Mr. Chairman, thank you. Regarding the journal and just some comments about how to store it, the tamper evident issues. We were considering looking at page 53, starting on line 17 through line 23, if the journal is maintained on tangible medium, shall be in a permanent bound. If the committee so chooses to maybe strike those few sentences and just making it broader to be determined by the notary how they want to store it in whatever means they want to, certainly we would understand that. We do feel that it is important to protect the notary by having the journal requirement, but do understand the issues of maintaining it and keeping it, and however that may look in the future. Regarding some of the changes that First American Title brought forth, we certainly understand and we will be happy to work with them on anything that needs to be put into rule for their purposes. We do want to look at some of it a little bit closer, certainly, but regarding the multi-factor authentication and the knowledge-based questions like what street did you live on in the 4th grade and things like that. We have heard from our stakeholders that sometimes that is problematic, that it took them too long to get through and they couldn't perform the remote online notary because of that. And just hearing from our stakeholders, that's another reason why we had opened it up like we did, but we definitely understand their needs as well as wanting to keep it on a platform for their purposes. Regarding the notarial officer versus notary public, that is correct. County clerks, judges, they don't fall under our authority. We do give them the authority to perform notarial acts in this statute, but if the committee chooses to remove notarial officer from doing remote online notaries and just have the notary public do that, I understand his point as well. We have not talked to those notarial officers that aren't notary publics just to see if that is something they wish to perform. And his suggestion could be taken that we could address that in rule as well.
So Kelly, I want to back up to the record keeping. Do you have any sense of whether or not that has to be in law, or can that be accomplished by rule, thereby making it a little bit more flexible and something that the Secretary of State's office can react to in a quicker fashion? What are your thoughts on that?
Mr. Chairman, we did want to put it in law because of the notaries that aren't doing it, that should be doing it. And testimony was given about that maybe they are just truly notary publics who do it for various purposes and really should track all of those employees of a bank or employees of another organization, they can leave at any time. So again, that education of they'll still be a notary, that they should be journaling. We could address it in rule, absolutely. This is Rulona language. It's important, we feel, that to protect the notary. And I do understand that there could be certain exceptions, but we do want to always protect the notary against those fraudulent activities or any bad actors. Even with personal knowledge, you still could have a situation where you might need to remember the exact situation of what you notarized and how you identified them. But it is certainly something we can address and roll if we need to.
Okay, thank you. Committee, any questions or comments for the Secretary of State's office? Anything else for the Secretary of State? Thank you again for all your hard work, ladies. Appreciate you sticking around also. Committee, I guess, what's your pleasure on this bill?
Do pass.
We're going to close public testimony, by the way. Nobody else having surfaced, and so we'll close public testimony and work the bill. What's your pleasure?
Do pass.
Moved by Senator Case, seconded by Representative Clausen. And I think this is the size of this bill. I'm not inclined to go page by page. But if there's any sort of order that we can do to this, I think let's just take a look at, say, page 1 through 5. I'll go about 5 pages at a time. We'll take it easy and slow and make sure that we collect all we want to contribute in the form of amendments or suggested changes. So pages 1 through 5, committee, anything on 1 through 5, anything from 5 through 10, pages 5 through 10. Pages 11 through 15. Pages 16 through 20. Okay. 21 through 25. 26 through 30. 31 through 35. Page 36 through 40, 41 through 45.
Scroll as fast as you're going.
I apologize for spurring the horse here. We have plenty of time to go back if we miss something. 46 through 50. I think we're coming close here, committee. Okay.
Mr. Chairman.
Mr. Co-Chairman, 51 through 55.
Thank you, Mr. Chairman. Starting on, in this section, on section 30, or portion of 32.3.118, starts on page 52. My amendments start on page 53. And this is going to be pretty robust, but it takes into consideration the fact that, well, I'll explain once, if I get a second, I hope for an explanation. Starting on page 53, lines 7 and 8, strike all. On line 17, after the period, strike the remaining of the line and strike the remaining of the page. Page 54, strike all. Page 55, strike all. Page 56, strike lines 1 through 7. Page 57, strike lines 14 through 16. I get a second, Mr. Chairman, I'll explain my.
Does everybody understand the motion? It has been seconded by Representative Duncan.
That was a mistake.
Well, let me explain.
So please.
Can we refer this to the Journal Committee first? Get a recommendation.
I like that.
Yeah, that's pretty-
Mr. Co-Chairman, tell us what exactly are you up
Thank you,
to?
Mr. Chairman. The intent of this section is to, as the Secretary of State's office stated, is to ensure that those notaries that are not keeping a journal are keeping a journal. I agree with that intent. At first I thought maybe just strike this whole 32(3)(118), strike the whole deal. But the intent of the Secretary of State's office to ensure that notaries are keeping a journal. So with that in mind, I got rid of the things that I don't think are enforceable or should not be enforced. Starting on lines 7A and on page 53, the 2-year requirement. We could go to 2-year, 6-year, or what have you. I think the requirement of just having a journal will handle that. I think notaries are going to keep that unto themselves. And then if we go into the bottom of page 53, we look at the requirement that it's got to be tamper evident if it's a electronic portion or if it's a tangible medium, as in an actual journal itself. It's a bound register. I think they'll handle that themselves. Page 54 is just, in my opinion, unnecessary added weight in regards to what the journal looks like. So it's page 55. And so is the last page or the last portion of 56 that is struck in regards to the personal identifying information. I think notaries will be able to handle that unto themselves. And then on page 57, the 2-year requirement, after they're no longer a notary, striking that. So basically, Mr. Chairman, the intent of the amendment is to keep with the thought that the Secretary of State's office currently has, which is that there should be a journal required, but just getting rid of everything that I don't deem to be actually necessary to be in law. I'm up for flavor.
Okay, thank you, Representative. Comments? Senator Schuler.
Mr. Chairman, and this is mainly just, I think you were going awfully fast for me, for us old timers. Did you strike all of page 54 and part of 55? I think I got everything else, but could you clarify that for me? Thanks.
Go ahead, Mr. Co-Chairman.
Yeah, thank you, Mr. Chairman. Senator Schuler, all of 54 and all of 55.
All 54.
And Senator Schuler, on through to page 56, lines 1 through 7.
Okay, I got that. Thank you.
Yeah. Any questions or further thoughts on this motion?
I think Mr. Hewitt has some. Just renumber as necessary, right?
For Hewitt.
And renumber is
Mr. Chairman, I'm just looking for possible permission to make conforming amendments as necessary. Would that be okay?
Please. Okay, thank you. Please do that. Okay, are we ready? Are we ready for question on the motion?
Question.
Okay, question having been called. All those in favor of the motion, please put your hand to the screen.
We got one over there too.
Okay, over here. Okay, all those opposed?
I'm over here on this screen, the one with your eyeballs.
Okay, that motion has passed. Okay, anything further on page 53 or over to page 56, because 54 and 55 do not exist at this point. So page 56, and remember on page 57, that motion strike lines 14 through 16. Okay. Page 58. And we'll take it page by page on through the rest of the bill. 59. Anything else for page 60? Okay, anything else for the rest of the bill? 62, 63 on through.
Yes, Mr. Chairman.
Go ahead, Mr. Co-Chairman.
Yeah, it's kind of a silly question, but it just seems like, and I don't know anybody on the committee can answer this. I would like to hear the thoughts, but it seems kind of silly to mandate be able to read and write English into the Notary Act. I mean, I understand it. I just don't understand why that's a requirement in the Notary Act. That's on page 59, line 6.
statute.
It's in statute. Be able to read and write English. I mean, I understand, Mr. Chairman, lines 11 and 12, to pass the examination required under Wyoming statute. I understand line 8 and 9 not be disqualified to receive a commission. I just think, boy, this is Wyoming. We've got, I think that's kind of.
You know, I want to go to one of our notaries, Representative Duncan. What are your thoughts on that?
Correct, Mr. Chairman, thank you. Correct me if I'm wrong. If you can pass the exam, isn't that implicit that you can read and write in English?
I would think.
I'm just asking. So that's kind of my thoughts of why do we need it written in statute if you can pass?
Can someone help you pass?
Theoretically, probably, but
You can't read it. Well, Mr. Chairman,
Go ahead, Mr. Co-Chairman.
would it be possible to ask the Secretary of State's office a question?
Absolutely.
Thank you, Mr. Chairman.
Would you mind coming back up?
up?
Kelly, thank you. What are your thoughts from the Secretary of State's office regarding this requirement on the ability to read and write English? I'm perfectly comfortable with requiring that.
Mr. Chairman, I just lost my page. Which page are?
Page 59.
59,
59. Thank you, Mr.
line
Chairman.
6.
And Mr. Co-Chair. Yes, this is actually current statute. It does say that in our current law. We do need to ensure that the notary can complete the certificate and know which notarial act they are doing, whether it's an acknowledgement or a certification or whatever they're doing. So that is the reasoning behind it. To your point, the education, the examination requirement, we do hope to make sure that that is something that the notary would be able to read and write English. So that should take care of it, but that's the reason.
Okay, Representative Duncan.
Thank you, Mr. Chairman. To refresh, it's been so many years and I just had to renew each time and not have to re-exam. So I don't even remember, was it an online exam or was it, I remember looking through the book and reading all the rules and everything. But the exam part, was it online or is it a paper?
Mr. Chairman, Representative Duncan, it was a paper. It was a self-help test kind of a thing, open book kind of a test. We do hope to move into something like an online module, something that you could just push through in the future. We don't have any funding right now to do that. So at this point, we've kind of just left it up to be flexible so that whatever that education looks like, that exam looks like, we can adjust with the times. And if we do have funding someday to make it into an online module, then we will do that.
Hypothetically, then I could get help to take that test.
Yes.
Thank you, Representative Clem, and then we'll go to the co-chairman.
Yeah, thank you, Mr. Chairman. A couple questions. Do we have any Spanish speaking and Spanish writing notaries at this time? And would there be value in having those who are perhaps bilingual? It seems we're living, Wyoming is becoming more and more diversified. And so it would seem that there would be some value in that. And so I wonder if this is actually in a real, I mean, at first I thought, well, this is kind of silly, get rid of the read and write English. But as I think about it, to acknowledge the times that we're living in our diverse population, perhaps it is better to get rid of. So your thoughts?
Mr. Chairman.
Go ahead.
Some states do have a system where they can tell you that this notary also speaks Spanish and will perform a notarial act. Our state does not have that, and we do not have that in the statute. It is something that we have been asked before. Certainly, do you know of a notary that is Spanish speaking? So I agree that it does have some value. To read and write English, though, we have to have, then they would also additionally be able to perform that notarial act in a different language. And some states do have that.
Can I follow up on that, Mr. Chairman?
Absolutely, Representative Clem.
Thank you. I guess my question is this, to have this, since we're updating the law, would it be of more value to strike this from the law to allow for that greater flexibility for your office? Should we diversify who, as far as not expanding the act any more than what it's expanded, but I mean, for those who can take part in it, is talking especially about those who speak different languages and allowing your office to perhaps even administer a test, maybe even in the future, a Spanish, for a Spanish test for those Spanish speaking people. Anyway, your thoughts?
Is it adequate then, if it's applied, if you take this out of the statute, as Representative Clem is suggesting, then it's simply implied? What are your
Mr.
thoughts?
Chairman, Representative, I think that as long as the notary can read and write the language that's on the certificate, no matter what that language is, it would satisfy it. So they know what they're doing when they're performing that notarial act.
Some of these documents are pretty complicated. Follow up, Senator or Representative Clem. And then I think the co-chairman, and then we'll come back to Representative Duncan.
Thank you, Mr. Chairman. Ms. James, in regards to the examination, certain agencies allow assistance during examinations. For example, if you're getting your driver's license and you don't read or write English, you can have assistance from someone that does. Does your agency allow for that?
Go ahead.
Mr. Chairman, Mr. Co-Chairman, we haven't necessarily contemplated that yet and how that examination will look. Currently, they have to be able to read and write English. So if you do strike that, then they would likely have some assistance.
Okay, go ahead, Mr. Co-Chairman.
Thank you, Mr. Chairman. Do you believe your office would be able to write rules and regulations and be able to handle this if we didn't mandate in law that you've got to read a certain way?
Mr. Chairman, Mr. Co-Chair, I do. We anticipate drafting some rules around the education soon.
We're gonna give you a little bit of rules work, it sounds like.
We're ready.
Representative Duncan, go ahead.
Thank you, Mr. Chairman. I just wanted to clarify, in my experience, when I've had a Spanish-speaking client who needed to sign documents and I had to notarize or something along those lines, I do speak Spanish, but very limited, and it's like high school.
Dos cervezas, por favor.
And so I have actually had someone come in and actually interpret the documents for us and then notarize, because I didn't know of a notary nearby to be able to refer the people to. So that's how I've handled it. But in terms of the exam, it's basically, it's a self-proctored exam. So if you get help, they would have no idea.
Mm-hmm. Okay.
Mr. Chairman.
Representative Clem, go ahead.
Thank you. If we're all set, I would make a motion, page 59, strike line 6.
Second.
Okay. Moved by Representative Clem, second by Co-Chairman Lindholm to strike line 6 on page 59. Any questions or thoughts?
And Mr. Chairman, just to renumber as necessary, obviously, so.
Okay, thank you, Representative. Are you ready for a question on that motion?
Question.
All in favor, please raise your hand to the screen to eliminate that line. All opposed? And that one passed, I believe, 6-5. I did not see a vote by Senator Nethercott on that one.
Did you get me?
And I got you. Let's try that. That's close enough. We're going to do that again. So all in favor of striking line 6 on page 59, please raise your hand. And I'm going to count one more time.
You are a lousy counter.
Those opposed?
I'm over here, Mr. Chairman, on the real screen.
Five to four.
Senator Nethercott's back.
And Senator Nethercott, did you vote?
I vote aye.
That motion has passed. Onward. Committee, anything else on page 59? Continuing on through the bill, page 60,
Mr. Chairman.
Mr. Chairman.
Thank you, Mr. Chairman. On page 60, line 7, strike 60, insert 50. And I'll explain once if I get a second.
Second.
Moved by the co-chairman, seconded by Representative Duncan to strike line, at the end of line 7 on page 60, the $60 and replace it with $50. Go ahead, Mr. Co-Chairman.
Thank you, Mr. Chairman. And the reason behind this motion is, as if we look back at every time we raise a fee in the legislature, it's never the amount that's talked about. It's always the percentage that's talked about. And I know this is silly, but optics are everything in this regard, and a 100% hike is going to be talked about considerably. And I think this more conforms with going to the 6-year aspect as far as the bump in price. It's easier to make a comparable value in that regard. If we were going 8 years, I could see going to the $60 because that would comport to our current price versus the years. And I think this is just an easier sell to the public.
Committee, any thoughts? Representative Bear.
Thank you. I don't disagree with any of that, but didn't we hear testimony that the total cost to the notaries who apply for a certificate is going to be less because they won't be paying for the bond now?
Mr.
And I
Chair,
believe that testimony, Representative Bear, was $10 per year now as you go to 6 years versus $24 a year that it used to be. So
and
I
Mr.
believe
Chairman.
those figures are right. Go ahead, Mr. Co-Chairman.
Yeah, thank you, Mr. Chairman. We also heard testimony that they no longer have to, the Secretary of State's office no longer has to send that certificate to the bonding agency. So that's a savings on the Secretary of State's office. And on top of that, they're moving to email versus sending it via mail. So that's another savings to the Secretary of State's office. So everybody's cost has gone down. And so that's another reason why I think it's purposeful to do this.
Representative Clem.
Yeah, thank you, Mr. Chairman. I just don't know if I have enough information on this. Trying to weigh all these things out, and the one thing that just, what I'm sensitive to, I'd rather have the fee be what it is right now as far as $60 and let it remain that way for a period of years versus moving it at 50 and then 5 years later, they're looking for another fee hike. And so that's the one thing that I'm sensitive to. And I'm not sure if the Secretary of State's office has any feedback on that. We've already heard that there is going to be a savings and hearing that, everything that Co-Chairman just mentioned is correct. That's the one thing that I'm just not persuaded. I just don't want to set something up for a future hike later on. That's what I'm trying to be sensitive to right now.
Well, Representative Clem, that's a good point. And that's part of the reason that I asked the question this morning. The flip side of the coin is that fee high enough? Because given the climate that we're entering now, we've been notorious for setting our fees far too low, in my opinion, allowing them to stay way too low to provide for the services to the state. And I think, Senator Scott pointed out yesterday that we're going to have a lot of votes and a lot of situations where we're going to have to do things we really don't want to do. We may be hiking fees. So I have that a little bit of heartburn putting it at too low of a level because I believe, like the representative, we may have to revisit in a hurry. But committee, any other thought? Representative Furphy.
Thank you, Mr. Chairman. Well, what we heard is that our fees at $60 would be just kind of in the middle of the range of other states. So I think raising it to that level makes sense to me. Thank you.
Thank you, Representative. Anything else, committee? Are you ready for question on the motion?
Question.
Any and all in favor of the motion, which is to strike 60 and make it 50? Please raise your hand to the screen. Okay, all opposed? please raise your hand.
Over here on the big screen.
And that motion fails. Anything else on page 60? Anything on 61? 62? Committee, we're all the way to page 63. Page 64.
Mr. Chairman.
Mr. Co-Chairman.
Yeah, thank you, Mr. Chairman. And I guess just for discussion, I would like to know from some of those with a notary on the committee in regards to disqualifying those types of people that have a felony or something like that on their record.
So any thoughts, Representative Duncan, or I guess I'm looking on the screens to the former chairman or to Senator Nethercott.
Can you give me clarification, please?
I think the question is in regard to those with felonies,
By the notary or
prior
the
convictions, or
Mr. Chairman.
go ahead, Mr.
Yeah,
Co-Chair.
thank you, Mr. Chairman. Starting on page 63 and over on to 64, the Secretary of State may deny, refuse, or renew or revoke a commission as notary public. And then if you go over to page 64, a conviction of applicant or notary public of any felony or a crime involving fraud, dishonesty, or deceit. And I guess.
Any felony is problematic.
Any felony is problematic
Yeah.
because it might be something that has nothing to do with notary requirements whatsoever. And yet but however, I will say this, Mr. Chairman, it does say on page 63.
It is permissive.
It is permissive. I'm a big fan of our current Secretary of State in his office. You don't never know who's going to be in there. And so.
That's a very good point,
Yeah.
Representative. I'll go to Representative Clem, and then Representative Duncan is on deck.
Thank you, Mr. Chairman. And I don't remember if it was corporations or if it was labor health, and we looked at how does that term, it was for boards and licensing boards in particular, and that they could deny licenses for, I can't remember it was an I word or something like that. And we changed all of that. That's the point. And so I'm wondering if it would be more prudent to, it is permissive, but on that page 64, conviction of the applicant or notary of public of a felony or a crime involving fraud, dishonesty, or deceit in relation to the act of a notary public, or something along those lines. That's what we've done with those other licensing boards. And so to be consistent, I think that might be something that we tried to do.
That was Senator Scott's
Committee, go ahead.
Well, Mr. Chairman, that was Senator Scott was really big on bringing both in this committee and I think in labor health with the practice acts that came out, then saying that the crime had to kind of be relevant to what we were trusting them to do. And he kept using the example of a medical license. If you had a hunting violation, that was a felony, and it wasn't relevant to the medical license. So that language is out there. He did a good job on that. And I'd suggest we do something like that.
That's a very good point, Senator. I'm going to go to Senator Scott since his name was invoked there. So, Senator,
is actually there.
Welcome aboard. Good to have you alongside. Please, you need to unmute, Senator.
There he comes. He's coming through this like the sunrise with that red hair.
Still needs to unmute.
You still need to unmute, Senator.
Unmute him on the
He's on the phone.
Oh, there you go. You're unmuted.
Okay, Mr. Chairman.
Good morning, Senator.
Mr. Chairman, apologize. I've had difficulties with my internet and low bandwidth. I would suggest that we amend it on page 64 to say a felony relevant to the duties of a notary.
Second.
My apologies. Who was the second?
The case.
Senator Case has seconded that. Anything else, Senator Scott, regarding the motion?
Mr. Chairman, that would be in line with what we did on Committee 10 on a lot of the licensure laws.
Question on that.
All in favor of the motion, please raise your hand to the screen. Okay.
Big screen.
Any opposed? I've got you in my peripheral vision. That motion passes. Anything further, Mr. Co-Chairman?
Thank you, Mr. Chairman.
Same page, 63.
Well, so technically that amendment went in on page 64. But there's similar language over on 65 that a notary public who is convicted of or pleads guilty or no contest to a felony or a crime involving fraud, dishonesty, or deceit shall notify the Secretary of State by written notice within 30 days of the conviction or plea. I guess my question for the committee would be, should we put something like what we just did on page 64 into here? Should they have to notify?
You know, I guess committee, one thing that we could have done before that motion, that's my fault. We certainly could have asked the Secretary of State's office for anything anecdotal or any thoughts you might have with regard to any denial that you've made in the past. I guess a question for you two would be, have we ever had someone wanting to be a notary who had a felony that you went ahead and allowed to be a notary? With that permissive language, have you really ever run into this, I guess?
Mr. Chairman, on the application, they have to certify that they don't have a felony or that it's been
Expunged?
Yes,
Or
yes.
there you go.
And we have had somebody bring in their documents showing, but we've never allowed anybody to be a notary that is a felon, admits to being a felon, and it falls under the public office statute because you can't hold a public office if you have a felony. And that's what a notary public is.
So there's some rule work that needs to be done based on the motion that we just passed, because we used the word relevant. So any thoughts about that? I mean, I would assume that through the rules process now, you can decide what felonies would be relevant to exclude somebody from the ability to be a notary, correct? I just want to make sure that we didn't tip over a bucket of milk. So Senator Case, thoughts on that?
Well, Mr. Chairman, I think Ms. Jane is saying that it's actually a higher standard than that because it's in a different part of the statute about holding an office. But while she's looking that up, maybe, I'm not sure we should change this section because this is the obligation of the person that's the notary to notify their licensor that something has happened. And it's the licensor that grants under our proposed amendment whether or not you can continue to hold a notary. So yeah, I think the obligation should still be there to notify. But to the bigger picture about this whole felony thing, felonies are really common in our law, and they apply to some really minor things. And it's a lifetime thing. If you have and so we really have to look at this just all the way through statutes, over criminalizing everything and then having the consequences follow our citizens for their lifetime. So that's why I support the kind of amendment that Representative Lindholm brought, or Senator Scott brought.
You know, I agree. At Senator Case, just to expound a little bit on that, the Wyoming Senate over the past several years, and I know that Chairman Nethercott has been involved since she has come to the Senate as well, but we've talked about that pretty extensively, and led by Senator Case, Senator Scott. Several of us have been concerned. If you go about trying to expunge a felony, some of us have tried to help somebody do that. And it is a very high bar. And the senator from Lander is very correct. We've got a lot of felonies, and we've got a lot of people who have stubbed their toe in the past maybe not to the level that should prohibit them from being a notary. But at any rate, I think Representative Clem had a comment.
Yeah, thank you, Mr. Chairman. On that note, property damage in excess of $1,000 is a felony. And we think about modern day electronics. We've tried to change that for years to no avail. But on to the topic at hand, this language that we see here that we're talking about is very similar to other practice acts. And so this is the duty to report. This is not any different than we've had in those other practice acts. So I would suggest that we do not change it.
Senator Nethercott, and then we'll go to Representative Duncan.
Thank you, Mr. Chairman. I know that we're looking at this particular issue as it relates to the ability of convicted felons to gain employment similar to the practice acts, right? That there needs to be a nexus to the occupation with the crime involved. The notary public position is a little bit different. And I do support that it needs to be a crime of dishonesty or deceit. But the other purpose of this is that the notary public adds a level of verification for the security of business based on their credibility, right? Like something's been admitted to court. It gives it a stamp of official approval that the person who signed it is who they were, so that business can be transacted accordingly. And so that notary is giving credibility to the document for that purpose. For the purposes of the court system, if you've been convicted of a felony and you're trying to provide testimony, that may discredit you in the judge's eyes or in the court's eyes. And so how your testimony may relate to a particular piece, it's a common question to be impeached or to deal with objectivity of evidence based on these particular pieces. And a crime of dishonesty, you're out immediately. It doesn't matter what you say under oath. You've already been convicted of a crime of dishonesty. We can tell that you can't tell the truth now. And so it's how all of that is weighed in our court systems is just kind of important to recognize. We're coming at it from what we're used to seeing is the relationship to employment and occupations and access to the workforce. There's a whole other piece to this. Nobody has a notary public job as a career, right? Nobody is out of the workforce for that. I mean, it's a service that industry provides, but it's not a primary position or function. It's a tangential piece to a job. So I just think that's really important in distinguishing it from our Practice Act conversations as opposed to the validity of the document being submitted and its purposes for use in a court system or any other business transaction. So just a different way to come at it and why that particular provision likely is in here, going back to the entire purpose of notaries in the first place.
Thank you, Senator. Representative Duncan.
Thank you. Mr. Chairman, just to tag on Senator Nethercott, just to put in context, the job of the notary, the number one job of the notary is to certify that the person in front of them that are signing the document is who they say they are. It's not to understand the document. It's not to interpret the document. The purpose of the notary stamp is just to certify that you are who you are. You say you are. I'm saying that I'm looking at your identification, acknowledging you are who you are, and signing and certifying that your signature belongs to you because I checked your documentation. So the notary just needs to know and be proficient in the notary certificate part, just the part on the bottom of whatever document it is to stamp and say you are who you are. They don't need to know anything else about that document. So just in context of similar to what Senator Nethercott was talking about, you're taking on the burden of verifying they are who they say they are. That's the gist of what a notary is.
Okay, thank you very much. Committee, anything else on page 65? And we have no motion at this point, so we can move on. And thank you again for, you're welcome to stay put, ladies, in case we need you one more time, okay? Thank you for that. Committee, on to page 66, 67, 68 and 69, 71, 72 and 73, 74, 75, Coming to the end of the bill.
Mr. Chairman, I just,
Go ahead, Mr. Co-Chairman.
I'm sorry. I just, I get caught up in language and unintended consequences or possibilities. We just, some of our testimony was from an attorney that is a notary public. And the law as it is currently written in this bill is implicit that they can't, that this does not give permission as a notary to act as an attorney in any way whatsoever. But it does say, so, and I'm talking about over on page 68, and over on to page 69. So the commission as a notary
68
public.
and 69.
Correct, Mr. Chairman.
Okay.
The commission as a notary public does not authorize an individual to assist in drafting legal records, give legal advice, influence or otherwise practice law, yada, yada. It says over on page 69, on lines 4 and 5, receive compensation for performing any of the activities listed in the subsection. Well, certainly the notary requirement that they get does not give them that authority, but their Juris Doctorate's degree and their bar does give them the authority to do that. And I think we all know what this means, and we're not trying to cross wires, but it does specifically say that they can't receive compensation for performing any of the activities listed in a subsection. And so I just want to be very careful that we're not accidentally keeping someone from practicing their job.
I'm sure they keep that line drawn.
Well, I mean, they do.
Chairman. Good point.
Mr. Chairman.
Go ahead, Representative Clem.
Yeah, and on that though, I'm just looking at 68 again, line 12. So a commission as a notary public does not authorize an individual. So it's just, a person could be commissioned, by the bar to represent someone in the field of law, but that's a different commission. This is just a commission as a notary public. And so it just well defines that, hey, as a notary public, this is what we mean. So I don't have the heartburn there just because of what line 12 and 13 says in page 68.
Okay, thank you, committee. On through to the end of the bill, final 4 or 5 pages. Committee, anything else on LSO 126, working draft 0.5? Anything else? Are you ready to take a vote?
Question.
Okay, question on the bill. And Katie, would you please, or Ted, thank you very much. If you'd like to take roll call on 126. Thank you.
Senator Case.
Aye.
Senator Nethercutt.
Aye.
Senator Schuler.
Aye.
Senator Scott.
Aye.
Representative Blackburn.
Aye.
Representative Clausen.
Aye.
Representative Clem.
Aye.
Representative Clifford.
Excused.
Representative Duncan.
Aye.
Representative Baird.
Aye.
Representative Furphy.
Aye.
Co-Chairman Lindholm.
Aye.
Chairman Landon.
Aye.
The motion is adopted.
Okay, thank you, Mr. Hewitt. Committee, we have another bill in this section. We're running a little bit behind this morning.
Yeah, we are.
How come he's always unmuted?
Yeah, he wasn't unmuted that time.
I'm sorry.
Great job, Representative by golly.
Mr. Chairman, if I could note, this is what it's like sitting next to Jim Blackburn on the House floor. So I'm glad everybody gets to experience this.
I think it's committee, in spite of the fact that I'm going to hold some people up, but let's take a 10-minute break. The committee needs a break, and probably so do our those who are testifying. So 10-minute break, and we'll be back in 10 minutes to take business code revisions. Thank you.
Did you give me that? Was that your only one? You sick bastard. You wore this? No.
Did you want to be muted?
Yeah. I can't be muted. Because as a fit.
Because it's a group.
Yeah,
This is the real
I'm
world.
done anyway, so. Right.
Mr. Chairman, you'll have to unmute the computer at Chairman Lindholm's desk.
Are we ready?
We're ready.
Okay, committee, let's come back to order. And the next order of business is business code revisions. LSO 092 version 0.5. And Mr. Hewitt, thank you again for being here. And if you're ready to walk us through that, we'd sure appreciate it.
Will do, Mr. Chairman. So this is 21 LSO 92 working draft 0.5, and it makes a variety of changes to the state's business code. This is the same draft the committee reviewed in September. It was not amended in September. And to remind the committee of the most significant change made in the bill, it has to do with how the Secretary of State's office provides notices and service of process to business entities. The draft provides the Secretary of State with the option to provide notices and service of process electronically. And it does this by amending Chapter 28 in Title 17. If you go to page 22 of the draft, you can see that 1728-101 is amended, and it creates a new subsection E. And this subsection requires each business entity and registered agent to maintain an email address that the Secretary of State may use to serve documents on that business entity or registered agent. And the key sentence here is on page 23, lines 18 through 20. And this is for registered agents. The Secretary of State may provide service of process, notice, or demand by electronic means to that person. And then just below that on line 22 in subsection E, if a business entity has no registered agent or the agent cannot be served, the Secretary of State may elect to serve the business entity by electronic means, and service is perfected on the date the electronic communication sent. I want to reiterate a point that Representative Clausen asked about at the last meeting. And that's that business entities would not have the option to keep receiving paper copies of these documents. This would be a grant of authority to the Secretary of State's office to send these documents electronically. So there's no opt-out. It, however, does not affect business-to-business notices or service of process. This is just documents from the Secretary of State. And so that's the big change in the bill, but there are other changes in the draft as well, unrelated to the electronic delivery issue. And first, the draft provides general rulemaking authority to the Secretary of State for several chapters in Title 17, and one chapter in Title 40. The draft also creates a reinstatement process for foreign corporations whose certificate of authority has been revoked. The draft aligns timing requirements for when the Secretary of State's office refuses to file documents because of some defect in the filing. And finally, the draft provides that if there is no statutorily set fee to convert a business entity from one type to another, the amount of the fee is the origination fee for the newly converted entity type. And so, Mr. Chairman, that's a summary of what the bill draft is attempting to accomplish. I'd be happy to answer any questions on it.
Committee, any questions for Mr. Hewitt this morning on draft 92? All right, Mr. Co-Chairman.
Yeah, thank you, Mr.
Fire the gun and take off.
I've got a
Here we go.
wild one for you there, Mr. Hewitt. Another committee.
Does that surprise you, Mr. Hewitt?
No bucking horses on this one, I promise. In regards to the legislation, it is a fairly broad topic, and the title is even fairly broad. Not that we couldn't broaden that even more if we needed to or wanted to. But I serve on another committee that is creating a new type of business formation. And I almost wonder if it would be easier, probably not for you, but it would be easier in the long run for this committee, maybe in the future, to think about just amending that whole new business type of formation into the business code revision bill like this, or if we'd be better off just to keep it separate.
Mr. Hewitt, any comments on that front?
Mr. Chairman, Co-Chairman Lindholm, I'm not sure I follow what the new business type that you're referring to.
Mr. Chairman.
Go ahead, Mr. Co-Chairman.
Thank you, Mr. Chairman. That new business type is a public benefit corporation, and the Blockchain Select Committee is currently looking at that. Public benefit corporations, I think they're in like 16 or 20. The Secretary of State's office could better cite that. It's like 16 to 20 different states already, and the state of Wyoming is currently looking at adopting that and putting that into place. And I almost wonder if it would be better served to be in this versus a separate standalone bill. It'll come to corporations regardless, but.
Yeah, I see what you mean. Senator Scott.
Mr. Chairman, I would urge us not to piggyback another bill in here. This bill has got major problems, and I think you would jeopardize the other bill by putting something else in it. So this bill's going to be plenty controversial, and I don't know whether we can cure its problems or not.
Okay, thank you, Senator. Other questions or thoughts that Mr. Hewitt can weigh in on? Okay, Mr. Hewitt, thank you. I'm going to call on the Secretary of State's office come up and maybe allow for the drilling down on some of the striking features of this bill. Good morning, ladies.
Good morning, Mr. Chairman, Committee. Lisa Gonzalez, Director of the Business Division, Secretary of State's Office. I have with me Assistant Director Jordan Gray. Okay, and we're here to answer any questions you might have, or you want us to further discuss the bill?
You know, Ms. Gonzalez, it would help me if you could just background this again. Just get us from there back up to here with this bill. Just at this point during the interim, what we're trying to do is to shore up the information that we have and why we arrived at where we did, so that we can take this forward to a session. So if you could, with that in mind, just expound a little bit, I think that would help me, and perhaps it'll help some of the others on the committee.
Definitely. Thank you, Mr. Chairman. We'll go ahead and go through the bill. There is repetitive language, and it really isn't in any particular order, so we may be flip-flopping back and forth through pages.
Thank you.
Okay, Mr. Chairman, we're going to go ahead and start on page 2 of the bill. This begins with the powers. This bill provides general rulemaking authority to the Secretary of State's office to promulgate rules and regulations to carry out duties specified in 3 specific chapters. Page 2, lines 6 through 10 refers to Chapter 14, Title 17. This is for Limited Partnership Act. Then we'll jump to page 4.
And Ms. Gonzalez, one more time, I'll just remind that we do have those out Zooming, and I just want to make sure that everybody can hear you.
Definitely.
This is valuable stuff, so
Okay.
thank you.
Thank you, Mr. Chairman. Okay, then bottom of page 4 is Chapter 21, Title 17, which is the Uniform Limited Partnership Act. And then we're going to jump to page 5, which is Chapter 2, Title 40, Trade Name Registrations. Language has been added for each of these chapters. The second component of the bill references reinstatements following revocation for foreign nonprofits. We'll go back to page 2 of the bill. Our office worked with Mr. Hewitt on creating a new subsection to this, which is 17-19-1533. That creates a method for foreign nonprofit corporations that have been revoked by our office. These entities have been revoked either by not filing an annual report or for not retaining a registered agent. This mirrors current law, Wyoming statute 17-19-1422 for a domestic nonprofit reinstatement. The next component of the bill refers to refusal to file a document. This begins on page 5 of the bill. The Secretary of State office refuses documents for different reasons. Under Wyoming statute 17-16-125, the Secretary of State's office must return or refuse documents with an explanation for refusal within 15 days of submission. For consistency and clarity in the filing times across all entity types, we want to change the time period from 5 days to 15 days. This has been added to the following sections. We go to page 5. It references trade name registrations. Page 8 is limited partnerships. Page 12, nonprofit corporations. Page 16 is uniform partnerships. Page 18, registered limited liability partnerships. Page 20, unincorporated nonprofit associations. Page 21, statutory trusts. Page 26, limited liability companies. Page 30 is statutory foundations. Now, Mr. Chairman, the fourth component starts on the top of page 22, which is conversions of entities. This sets a fee for any entity conversion. This section has been added to prevent situations where an entity can pay less for the formation of filing of one entity type and then converting to another entity type. This bill provides that no fee is, if there is no fee set in statute, the fee for conversion shall be equal to the fee of the new origination of the newly converted entity. The last component adds notable changes to the bill. It begins on page 22 through page 26. This section is important to address statutory changes that are tied directly to required budget reductions that our office put forward to the governor. The changes we are requesting create an alternative approach to provide legal notices and service a process to business entities other than through the mail. In the current law, an entity can opt to allow the Secretary of State's office to send legal notices to them electronically. This portion of the bill creates an alternative way to send these notices electronically without first receiving permission from the business entity. Within this section, there are a sequence of amendments that specifically authorize this electronic service by the Secretary of State's office. The primary change that allow this happens in Chapter 28, Title 17. The chapter amended to require registered agents and business entities to provide and maintain an email address that the Secretary of State's office may serve documents on the business entity or the registered agent. These changes within Chapter 28 of Title 17 take place on pages 22 through 26. Alongside those changes, there are variations of Title 17 that discuss notices and service of process delivered to the Secretary of State's office. They are amended by adding language to allow these services by electronic means. If you go to page 7, it references cooperative marketing associations. Page 8 through 11 is corporations. Page 16, partnerships. Page 17 through 19, registered limited liability partnerships. Page 20, statutory trusts. Page 27 through 30, limited liability companies. Pages 31 to 32, statutory trusts. Mr. Chairman, these notices are trade name and trademark renewals, notices to entities that have not filed an annual report. Prior to mailing these notices, they do receive 3 courtesy email notices, 60, 30, and 10 days prior to the due date of the annual report. Dissolution notices to entities that fail to file annual reports are also mailed. These required mailings total over 12,000 notices a month, which equates to 156,000 mailings a year that our office mails out. The cost of these mailings is $85,800 a year. $175,750 was the mailing budget for our office a biennium. $143,520 is what the reduction we have made in our mailing budget to meet the 10% budget cuts that the governor has asked for. $32,230 is remaining a biennium for the entire office, or $16,115 a year for the entire office. Without the statutory change, the $32,230 that is left in our budget for mailing costs for the entire office will be depleted within 2 months. Mr. Chairman, this is a quick assessment of the bill. We are here to answer any questions.
Ms. Gonzalez, thank you. That was very detailed and I really appreciate it. Committee questions for the Secretary of State. First, Senator Scott, and then I'll go to the co-chairman.
Mr. Chairman, and I'm going to have a lot of questions. Mr. Chairman, my first one is when you're sending a notice by email, how do you know whether they got it or not? If you send it by mail, eventually that comes back if they didn't get it. How do you know whether they got it by email or not?
Ms. Gonzalez?
Mr. Chairman, Senator Scott, we should receive a bounced email back indicating that we did not receive that notice as well. And to mention with our mailings, we do receive approximately 1/3 of those back undeliverable.
Can't you put a confirm on those emails as well?
Mr.
Confirm
Chairman.
that it's been opened?
Yeah, that's what I was going to ask, if they had that in place.
At this time.
You can defeat that as a recipient.
That's a.
I'm sorry, Mr. Chairman, I did not hear the question.
Oh, so
But there is,
it can be ignored. I'm hearing from,
however, there's other software out there that tracks it.
and we can talk about that.
I mean, that
So-
could be something we can check into for
Many
you.
people talk.
So Senator Scott, what the conversation, you have led us into a conversation about whether or not there are programs available, and they are there, that would allow for the Secretary of State's office to know if that email has been opened. But go ahead, Senator, you had other questions?
Yeah, Mr. Chairman, the concern I have on this bill generally is not so much with I think the larger corporations are going to be fine. Most of the domestics are going to be fine, but I think you've got a subset here with particularly domestic corporations that's going to get in trouble with this. And I think your troubles are going to come in from the email requirement in three ways. And I'd like Secretary of State to respond to this. First, it seems to me that you have a requirement that if they change their email, they notify you, but I bet a lot of the people don't do that. That my observation is people tend to change those, sometimes for economic reasons, sometimes because the marketers learn their email address too widely and they get too much junk. And the state of Wyoming is capable of being classified in that area because they send out an awful lot of emails. And so I think that's a potential problem where you no longer know, in spite of the requirements, you no longer know what the email address is. Second, it seems to me that there's a fair risk of somebody having their email sent to their junk mail category. I see that happening in ways I never expect on a computer. You find that you push the wrong button, you lose something. I think that's a risk. And then the other one, which I think is a good deal less common, but will happen, certainly in the agricultural area, there's a lot of ranches that are incorporated one way or another because it's the best way to share ownership amongst family members. And I know there's parts of my district where you cannot get any kind of internet service at all due to the configuration of the mountains. And other areas where the only stuff you can get is satellite that can be very expensive. And so people in those areas don't have the email capability. And I think we need to continue to provide for those. And I was unable to figure out how to amend this bill to cure that particular problem. And Mr. Chairman, it does seem to me that this is a big money-making area for the state in terms of the various corporate work the Secretary of State's office does. And I think we need to somehow put in a provision where people who can't get email can opt out, where if the email service fails, that then as a mail notification. I just haven't been able to figure out how to do it, Mr. Chairman, but I'd like to hear the Secretary of State's feelings on that.
Thank you, Senator. Ms. Gonzalez, what about this technology stuff? And should we write into the bill some sort of a backup mechanism and then go to appropriations to find the money so you can mail some of them?
Mr. Chairman, that is correct. It would take a fiscal impact in order for us to make the system compatible to find out, indicate which entities do not want this capability to happen. Right now, everybody does receive this by email already, and then they do receive a paper notice. As far as email addresses, it's the same thing we run into with mailing addresses. If they don't keep a current mailing address with us, they come back undeliverable as well.
What kind of percentage come back in snail mail?
Approximately 1/3 of them.
1/3.
Mr. Chairman.
Wow.
Yes.
Representative Clem.
Yeah, thank you, Mr. Chairman. And on that note, what do you do? What's the process when a third comes back undeliverable through snail mail? I mean, what is the process after that? What do you all do?
Mr. Chairman, Representative Clem, what we do is we scan in the notice indicating that it was returned because undeliverable. It's proof to us or to the customer that we did attempt to send this notification to them. And we have proof that it was sent back for not maintaining a current address with our office.
Okay, follow up,
Yeah,
Representative
thank you,
Clem.
Mr. Chairman.
And I'll go to.
Appreciate that. And on that note, would you all do something similar? I take it if we were to move to electronic means, how would you all handle that with email addresses? Would it be something similar? And the reason I'm asking is I understand the angst of moving in this direction, yet this is the direction that our world is going to. Almost everybody, especially if you have a business, you're going to have an email address of some kind. And so, but I understand this opens up new problems for the Secretary of State's office. And so I guess what I'm trying to figure out is yes, indeed, we have problems with our existing system as it is. And it's likely we will have existing, or we'll have new problems if we go the email route. But are those problems insurmountable? Do you think they'll be less than the snail mail issue? I guess that's what I'm trying to figure out, if this will actually improve things overall versus be a step backwards.
Any sense of that, Ms. Gonzalez?
Chairman, Representative Clem, if this bill does pass, our system currently has a way for us to indicate which entities do have a problematic email address. Our duty would be to call these entities and try to get updated email addresses from them and mailing addresses as well, having them complete what we call an update form. It's a form where they can update any information as far as their mailing, principal address, and email address. And we would hope this would help some of the problems we're having with the rejected mail or returned mail.
Senator Scott, we haven't forgotten about you. I know you've got other questions. We're taking a little bit of a sidestep here with a couple of questions related to what you have brought up. So I'm going to go to Representative Clausen next.
Thank you, Mr. Chairman. Was it contemplated an opt-out provision? And then, so this is geared towards financial savings, even if we caught, and maybe this is something you can't project, but assuming you caught 70% like the regular mail or U.S. Postal Service through email, 90% through email, 95%, you're still catching whatever that percentage was in savings. And then have an opt-out provisions. So I'm assuming it's somewhere between 5 and 45%, right? With the, I don't think there's any way to find solid numbers. Maybe you guys have solid numbers. So we still budget for that percentage with the opt-out until we can figure this out. I'm calling it a soft landing provision because switching from 100% U.S. Postal Service to 100% email, I don't see this being without its own, which is just by itself. Do we have kind of a soft landing plan, an opt-out provision somewhere in there? If we projected how many we're gonna not have emails addresses for, that's kind of where I'm looking.
Ms. Gonzalez, did you guys talk about a compromised landing spot during your deliberations on budget and how to get word out to businesses?
Mr. Chairman, at this time, we don't have a soft spot in plan right now because of the budget reductions. This is why we want to implement this, is due to budgetary cuts.
Okay, good point. Mr. Co-Chairman, and then we'll go back to Senator Scott because I know he's got other questions as well.
Thank you, Mr. Chairman. Ms. Gonzalez, appreciate your testimony and appreciate your work in this regard. I happen to be a little different than some of my peers. I personally don't care if somebody doesn't have an email address. It's 2020. Yeah. It's time to cowboy up. Get real about this. So
on a tall horse,
but
and you can't get it on your phone.
That's right. And my concern in this regard would lie where the other competitors for Wyoming do lie, Delaware, Nevada, and those states. Where are those states' provisions in this regard? Would this be something novel for comparatively to our competitors, or have our competitors already moved in this direction?
Ms. Gonzalez.
Mr. Chairman, we really haven't looked at the other states as far as what they're doing with notices like this, but we can do some research.
That'd be great.
Okay.
Yeah, thank you.
All right, committee, let's go back to Senator Scott. You said, Senator, that you had a couple of other things.
Mr. Chairman, we've covered most of them. I would respond on the business of the competitors. I suspect that isn't going to make any difference. I think this one here, the problems are caused for the smaller businesses within the state that would naturally tend to incorporate here, and where there may be difficulties. And I think some of the difficulties are going to stem just from not being sophisticated enough in the whole business of how you manage emails and, you got to notify the Secretary of State when you change yours. That I think will cause quite a bit of trouble. And there will be, I think there'll be relatively few, but there will be some who cannot physically comply with this. And Mr. Chairman, if we're going to be business friendly to particularly the small in-state businesses, I think we need to have some additional provisions here. And I haven't been able to work them out as to how to amend this bill to fix that. And yes, we've got the budget problems, but we're talking here about a place where we're earning money for the state. And I think having the ability to have people deal by mail where the other doesn't work is important in terms of staying business friendly and continuing to earn the kind of profits we do off.
Thank you, Senator. Committee, anything else on business code revisions with regard to the Secretary of State's office while we've got them up at the front?
Yes, sir.
Representative Duncan.
Thank you, Mr. Chairman. I think I asked this before, but it's been months and a lot's happened since then. Could you tell me what is the, do most people when they renew their license, you know, their Secretary of State, they have to file and all that. Do most of them at this point already are doing them online versus in paper by mail? Do you have any guesstimate on that?
How about maybe a WAG?
Mr. Chairman, Representative Duncan, approximately 75% of them do file online. The others do the traditional paper filing, or what we call a pending annual report, where they complete everything online, but they submit it by paper with a check or money order rather than filing with a credit card.
So follow up, Representative Duncan.
So, thank you, Mr. Chairman. So 75% of those, even those who are filling it out online and then sending a check,
they're still getting mail.
They have an email address, correct? Because they're logged into the system, correct? Or am I misinterpreting?
Representative Duncan, yes, they should have an email address. The ones online definitely do.
Okay.
Mr. Chairman.
So just for clarification on that point, Ms. Gonzalez, even those who are filing electronically, are you still sending paper copied mail to those who primarily operate with you electronically? Is that part of the savings that we're talking about here? Or are the mailings just going to that 25% and that's the savings?
Okay, Mr. Chairman, we don't actually send out the annual report itself. It's notifications reminding them that they do have an annual report that's due. So it, what would you say, it goes out to 75?
So if I operate primarily via my email in my dealings with you, I don't really need an envelope from the post office. Does that make sense? And am I still receiving one if I primarily communicate with you electronically?
Mr. Chairman, you do receive a notice and then you would file your annual report online and you would get an email stating that we did receive it and it has been filed.
So the savings that we're talking about in this bill, the 85,000, for example, on mailing cost, that's just simply in that 25% that you, if I'm receiving everything via the post office and communicating back to you via the post office, that's the savings that you talked about if we go to electronic.
Mr. Chairman, that is correct. The mailings of them, yes.
Okay, thank you for that. Senator Case.
Mr. Chairman, I was just going to make the point that if you fill out your form online, but then print it off and mail it in, they don't ask you for your email address in that circumstance. You can do that without an email. Then you have to mail in a check.
Okay, thank you for that clarification. Representative Duncan.
Thank you. Thank you, Mr. Chairman. However, in order to access the website to file your report, they do require an email, I believe.
No, this is the way I do it all the time, Mr. Chairman. So you can always go to file your annual report. You get a form, it's a fill-in form, and then at the end, you can submit it online, or you can print it off and send a check. It's the print it off and
It's the
send a
print it
check
off
that
and send-
avoids the
okay.
email.
Thank
piece.
you.
Ladies, we're going to morph into a little bit of conversation on this bill. Before we go to public comment, I want to make sure that we still have you here, though. If you hang tight for just a little bit here. Committee, anything else for the Secretary of State or any comments that might lead us in the direction of needing their reply? Are we good? I actually, committee, Katie, I do not show anybody who has an interest in testifying from the public. Has there been any latecomers to the chat room that we can bring in? I guess Mr. Meyer has showed up on the screen. So Scott, I apologize. I didn't have you down as speaking on this bill, but you're welcome. So let's go to Mr. Meyer.
Thank you, Mr. Chairman. Scott Meyer, as an attorney that does a lot of corporate practice and has a lot of clients that have to do annual reports and all the stuff that goes with it. I will tell you, I stand in complete support with the Secretary of State's office and this proposed bill. I guess if listening to some of the conversations that had happened that or just had taken place, that maybe you put something in there that it's email unless you otherwise elect, and maybe that addresses Senator Scott's questions. But almost everything that I get comes via email, and I make sure that when we are filing annual reports or we're setting up companies that they have not only my email, but they have my client's email so that they're getting copies as well. I think it makes a lot of sense. And frankly, you know, a lot of what, you know, the business division sends me as the form of mail will automatically probably go into the recycle pile because I've already gotten an email from them and I already know exactly what's happening. And what I need to do is to remind my clients, you got to get an annual report in. So I applaud the Secretary of State's office. I think this is a good move, and it would obviously would help save them money, but it saves me a lot of time if I don't have to go pick up that mail. And I'll stand for any questions.
Thanks, Mr. Meyer. Any questions, Mr. Meyer? Thank you very much. Senator Nethercott, go ahead.
Chairman Lennon, this is probably more appropriate for discussion, but in relationship to Mr. Meyer's testimony, I just think that's a wonderful solution that'll be electronic unless otherwise elected. And that way for, you know, those folks who don't have electronic access, that they can still get it via mail. But for the predominant, those who do, it really is an excellent service and it works really well.
Okay, thank you, Senator. Mr. Meyer, thanks again for weighing in on this. We appreciate you. I guess I'll throw it open in case anyone else is within earshot who wants to provide any public testimony. Going once, going twice. Okay, we're going to close public testimony. Committee, what's your pleasure on this bill?
To pass.
Move to pass by Senator Case and second by Representative Ayer. Discussion. Amendments. Senator Scott.
Mr. Chairman, I'm wondering, I think that the problem really is confined to a relatively small part of our local small business community, where I think it will cause problems. And I think Mr. Meyer's testimony was compelling for those that can afford to hire a lawyer. It's the people who, that would find that to be a major expense given the size of their business, and that I think we're going to get the problems in. I think we could cure some of the problems if we put in on page 22, line 12, an amendment that says, unless after email, it says unless they opt out of the email address requirement. That might cause us to have to make some further adjustments in the bill during session. But I think if you retain just a small portion of the clients as ones that are going to deal by mail, the cost won't be excessive, but will be much more business friendly to the smaller end of the business community and some of the agricultural community. So, Mr. Chairman, that's my motion, is to put that amendment in right there.
That committee, that's somewhat conceptual. I believe it goes into line 12 on page 22. If I understand correctly, Senator, that's where you intend for that motion. Do I have a second? Does anyone want to make that second? Seconded by Senator Schuler. Mr. Hewitt, are you following the good senator from Bates Hole?
Mr. Chairman, I am following. I would also recommend adding that proviso to 1728-104, which is at the bottom of page 3 and on to page 24. And then there are other provisions in this bill which under current law allow folks to opt in to receiving electronic notices. And it would probably make sense to rework those a bit so that there's an opt-out provision in there as well. And for example, page 7 has one of those for cooperatives.
So, Mr. Hewitt, you just referenced in law already. I'm thinking that maybe that language is not contained in the bill currently, and you would bring that in with this conceptual amendment?
Mr. Chairman, there are a few of those provisions in the bill that allow the opt-in for electronic notices. So it would just be a matter of reworking those a bit. I don't have specific language for you.
Okay, committee, does everybody understand what this conceptual amendment is and what it would do? Okay, are you ready for the motion? All in favor of the motion, please raise your hand to the screen. Okay, all those opposed to the motion, please raise your hand.
I know you got good provisions.
That motion has failed. I believe it was 7-4. Committee, anything else on this bill? We're not going to go page by page. Any other amendments? And if so, you can take us to page numbers and line numbers. Anything else on this bill? Are you ready for the question? Okay, Mr. Hewitt, would you please take roll on LSO 92, working draft .5?
Senator Case.
Aye.
Senator Nethercott.
Aye.
Senator Schuler.
Aye.
Senator Scott.
No.
Representative Blackburn.
Aye.
Representative Clausen.
No.
Representative Clem.
Aye.
Representative Clifford.
Excused?
Representative Duncan.
Aye.
Representative Ayer.
Aye.
Representative Furphy.
Aye.
Representative Furphy, I record an aye, is that right?
That's correct. Aye, yes.
Co-Chairman Lindholm.
Aye.
Chairman Landon.
Aye.
Motion is adopted.
Thank you, Mr. Hewitt. Moving on, committee. Next up, security interests in motor vehicles. Consideration of draft legislation to amend the time of perfection of a security interest in a motor vehicle. And we will consider LSO 89 0.3 motor vehicle security interest perfection. And Mr. Hewitt, we would be grateful if you could walk us through this fine piece of legislation.
Will do, Mr. Chairman.
Oh, we're an hour behind.
There he is.
Hey, Jim.
Morning, Representative.
Oh, shoot.
Hey, thank you, guys. Thanks a lot. Good job.
Thank you.
Thank you, everyone. Appreciate. For those attending in person, we were just waving so long to the Secretary of State's office. Appreciate all their help this morning. So sorry for that interruption, Mr. Hewitt. Please take us through this bill draft.
All right, thank you, Mr. Chairman. So this is 21 LSO 89 Working Draft 0.3. It has not been amended since the committee's September meeting. And just as a reminder, the draft amends 31-2801, which governs how creditors can perfect a security interest in a motor vehicle. So under current law, there are two ways to perfect that interest. And the first is shown on pages 2 and the top of page 3. And that's by filing a financing statement or security agreement with the county clerk and having the security interest endorsed on the certificate of title for the vehicle. Or in the second approach, as down starting at the bottom of page 3, that's by filing a transitional ownership document with the county clerk. And so this bill draft reworks the time that the security interest is perfected in a vehicle. Under both of these methods, the time for perfection under the draft becomes the time of delivery of these documents to the county clerk, rather than the time of filing as provided under current law. So you can see the references in the draft to the filing of these documents is consistently changed to the time of delivery or delivery to. So with that, Mr. Chairman, I'd be happy to answer any questions on the draft.
Committee, any questions for Mr. Hewitt? Committee, just I wanted to call your attention to a document that was contained in our packets, which outlines quite a bit of work by the County Clerks Association of Wyoming. So please reacquaint yourself if you haven't read that. It's a lot of work has gone into this bill, and I wanted to go to Senator Case because it was his work who brought this to the fore and encouraged the Corporation Committee to take it up, I believe. If not encouraged, we encouraged you to bring it to us. So, Senator, can you tell us anything more about this bill?
Well, Mr. Chairman, thank you. I think there is a path through this bill. These folks have been trying to meet and work out some differences that'll get the concurrence of the county clerks on this process. Just from a high level overview, I think you remember some of the discussion that it kind of revolves around this. Car dealers sell cars. They're very expensive during the time period from when a car is actually sold to when the security interest is perfected by having a title. A lot can happen, and that can be, we learned last time that was a fairly lengthy amount of time. It could be several weeks. And during that time, there is exposure with respect to the collateral of the vehicle and the possibility that the purchaser of the vehicle may have bankruptcy. I suppose there are other events that could happen which jeopardize the automobile dealers and the finance company and the bankers from having a perfected security interest in that vehicle. So, I started working on this last year. Basically, that was the bill you see here. But there has been a lot of good work done, and I especially want to commend. There's a county clerk up in your neck of the woods, Mr. Co-Chairman, Linda Fritz, she thought out of the box on this and came up, I think, with a solution that Representative Clark Stiff, who practices bankruptcy law, kind of moved it forward and put it in language. I know that other people have been involved, certainly the bankers and the automobile dealers, and I know the clerks have been talking among themselves. So I actually think we have a proposed amendment and a solution that works for everybody. So I'm just cutting to the chase.
I appreciate that, Senator, and obviously Ms. Freeze from your neck of the woods has been involved in this. Several calls from folks. Committee, we have several who would like to testify on this bill, and we'll get to that in a moment, just as soon as I make sure that there are not any questions of the senator before we progress to some testimony. And I'm going to give Representative Stiff the microphone first. Good morning, Representative, and thank you for being here at Corporations this morning. What can you tell us about the work that's gone on?
Well, good morning, Mr. Chairman. Thank you very much. I keep crashing your Corporation Committee meetings, so thank you for your indulgence. So I'd sent proposed amended language to, I believe, the co-chairman or Senator Case and others. And essentially, I think the idea here is that it gives the bankers what they're looking for, which is to be able to have a perfection of security interest in a motor vehicle happen effective as of the time they deliver a completed application for title to the county clerk. The slight additional burden of this proposed change onto the county clerks is that when they actually issue the title, they would be putting 2 dates on it. They'd be putting the date they issue the title, and then they would also be noting the date that they receive the documents in their office. And this would collapse the 2-step process into 1 step. And I think the virtue of it is that it actually takes advantage of what's a comment that's an existing law in the Uniform Commercial Code, revised Article 9. There's an official comment 5 that advises the state legislature to amend applicable certificate of title statutes to provide that perfection occurs upon receipt by the appropriate state official of a properly tendered application for certificate of title on which the security interest is to be indicated. So basically, this proposed amendment to the bill in front of you would take up the official comments recommendation and implement it. So I've sent that language on. I don't have a particular dog in the fight about this one. I don't know that the current system is all that broken, but this would solve a problem for the bankers. And the issue is that, broad picture here, the issue is that there's a 30-day clock essentially for the car dealers and the bankers to get a security interest perfected. From that 30-day clock starts when the customer drives the vehicle off the car lot. If the perfection of the security interest does not happen within 30 days, then the bank is at risk of losing its money because a bankruptcy trustee in an eventual bankruptcy by the purchaser of the vehicle could set aside that security interest, set aside that lien, and the bankruptcy trustee swipes the vehicle. So there's this 30-day clock that's set in federal law. What these proposed changes would do would effectively give whatever processing time is in the county clerk's office, whether that's 3 days or 5 days or 10 days, essentially it saves that time. So I don't know if that was clear or not, but I'll stop talking. I think this is a workable solution that gives the bankers what they want while preserving to the county clerks their authority to review certificates of title, applications for certificate of title, to make sure they're complete, right? So, Mr. Chairman, do you have any questions for me?
And Mr. Chairman,
go ahead, Senator.
Don't mean to interrupt, but I did supply that proposed amendment to Mr. Hewitt. I have a tracked-in version here to make it a little easier. There was a little bit of back and forth on the amendment. I think I have it in the final form, but I have not settled on the of yet. I'm waiting for this word of to be resolved. There seems to be a lot of controversy.
I really do appreciate, Representative, you lending your assistance to this effort and working with Senator Case and our clerks and with our bankers. So much appreciated. Committee, anything else for Representative Stitt before we go to some others who are here this morning? Okay, thank you, Representative. If you want to stand by, we'd appreciate it. We may have to come back to you. Ms. Langford, we'll go to you first. Good morning. Not quite unmute. There you are. Now you're muted again. Good morning.
Mr. Chairman, am I on now?
You are.
Thank you. On behalf of the Clerks Association, and we have 3 clerks that are on the call this morning, and I think I'm going to defer some of my discussion to them, and particularly to Clerk Fritz. She's the one that has done most of the work on this. One of the things that I would, like to say, I appreciate that we've been able to come up with some agreeable language. One thing that I do think the committee needs to be incumbent to know is that the county clerks in the state of Wyoming have just endured the biggest event of their careers over the last week or so. And most of the work on this piece of legislation has been done since last Wednesday. So they've not really had an opportunity to really look at this and digest it and comment on it. And so I think that on behalf of them, we need to have just a little bit of an opportunity. If the bill does go forward today, know that all of our clerks have not had the opportunity to really digest on this. But with that, I would suggest we go forward with Clerk Fritz, and she can discuss her research. I think that Representative Steth has really helped us to get to the language that we need for an amendment. And if there's any other comments, Clerk Gonzalez is on, as well as Clerk Freeze. And thank you, Mr. Chairman.
Ms. Langford, I'm going to step aside from the current conversation and back up just a moment to thank you and to, and hope that you will share with all of your fellow clerks out there how proud we are of the work that was done throughout the election process this year. Hearing and listening to what's going on out across the country. You guys are rock stars, and it means a lot and I'm very, very proud of where Wyoming is on this. So thank you for all the effort and getting through last week. And thanks for being here this morning. Okay. Next up, I've got, let's go to Mr. Meyer first. We're just going to go right down the list. So Mr. Meyer, welcome back.
Thank you, Mr. Chairman. Members of the committee, Scott Meyer with the Wyoming Bankers Association. I did have an opportunity, I think at our last meeting, we asked that you push this off into November so that we would have a chance to talk. I had an opportunity to meet with Clerk Freeze and look at all of how she does stuff. I've had an opportunity to talk with Clerk Fritz. I've had an opportunity to talk with even our local clerk to some extent, but I will tell you, these ladies really have explained and showed me exactly how things are working, and I really appreciate all their time. And I will tell you that I do think that Representative Stith did an excellent job stepping up and seeing what he could do to help work through that, especially considering his background in bankruptcy and understanding where the issues were. Senator Case was right. I think that we've taken that bill and we have made some modifications to it. And I think that those modifications work. I think that they do exactly what the bankers need, in the fact that they're trying to get that effective date earlier so that we don't run into the problems of the 30 days. And I think this does that. I look at where we were and where we are now, and I think that there's been, we're light years ahead of where we were a couple of months ago. I think the bill does exactly what we needed to do. And all I can say is thank you to everybody that was involved. It just is a great thing when all of us can work together and come to this kind of conclusion. So with that, Mr. Chairman, I will stand for any questions, but I believe this bill is probably ready to go.
Okay, Mr. Meyer, thank you. Committee, anything for Mr. Meyer? Okay, we're going to move on. Thank you, Scott. Really appreciate it. Ms. Fritz, thank you for all of the efforts, and we're going to wait till you get unmuted there. And welcome. Good morning.
Good morning, Mr. Chairman. And committee, thank you for listening to our changes on this today. There was one final change that I had emailed out really recently. I'm not sure if it was incorporated in that bill. I am on vacation this week and I am at home, so I don't have anything to print that with. It was that we needed to add behind application for certificate of title and the most recent record of title, or the most recent title of record, excuse me, that needs to be added. Otherwise, we are just duplicating the transitional ownership document laws. So there goes my cat. They need to submit the title with it as well.
You've got company there this morning, I see.
Yeah, sorry.
No, that's quite all right. And Linda, we did receive that language, I believe, and I'm hoping that Senator Case maybe has that as well, and we can incorporate. But again, thank you for all your efforts. Anything else that you'd like to share this morning?
I think this bill will work. It does not create much of a hardship on the clerks, and I think it's very helpful for the banks. And I thank you for the time for letting us work this out together.
Absolutely. And we appreciate you taking part of your vacation to spend it with a great group of people this morning. Any questions of Ms. Britt? Okay, we're going to continue on. Ms. Freeze, I see you're on the screen this morning. And
Mr. Chairman, Senator Schuler has a question.
Oh, Senator Schuler, my apologies. Senator Schuler.
Thank you, Mr. Chairman. Yeah, I just had a question for the clerk, wondering about of the problems with the delays. Has it been a result of in-state vehicles being purchased, or are there problems with when you purchase a vehicle out of state and they maybe come, from Utah or Colorado or whatever, and then they drive, back to Wyoming? I just wondered where the issues are happening with the delays. Thank you.
Or Ms. Fritz, in your case, it might be coming from that state to the east and driving back over to Crook County, but go ahead. Any thoughts on that?
Mr. Chairman, Senator Schuler, we have, for the counties that are bordering other states, usually we need to have bin inspections. We have factory cost questions. They don't send the entire dollar amount to actually make the title and apply the lien concurrently. So that holds up all of the counties that have surrounding states. That's where most of the purchases are made. Also, just as a little informational piece, I had gone through 2 months worth of security agreements that were filed at just Crook County, and we're a small county and we file pretty much as soon as we get everything that we need. And of the 218 of those security agreements, 98 of them were well beyond the 30 days because we had not received them in time. So that it was also part of the issue. So the clerks have done the best they can to file the liens in a timely manner. We just have to wait for a lot of paperwork to get there. Thank you.
Senator Schuler, any follow-up?
Oh, thank you. Thanks.
Thank you. Anything else for Ms. Fritz?
Mr. Chairman.
Senator Case.
Mr. Chairman, can I check signals with Clerk Fritz?
Absolutely.
Your suggested language in your email, Clerk Fritz, would it go in both the new section A and the new section B, or would it go in one or the other? Because, and I'm jumping ahead a little bit, but I'm trying to be efficient. In section A, there's the word with the amendment, a properly tended, completed applications for certificate of title. And I was wondering if that insert would go there. And then in B, there's the language, application, let me see, the clerk shall note on the face of the title the date that the security agreement or financing statement, a completed application for title, I think it would go in inserted there, was properly tendered to the clerk. Would it go in both places or one place?
Ms. Fritz?
Mr. Chairman and Senator Case, I believe it would go in both places. There was also a page 3 that I don't know, as I don't have it in front of me, maybe Clerk Freeze can speak to that. It may also need to be inserted on page 3.
And Mr. Chairman, I see that as well, and I think probably you're right. So all 3 places. We'll handle that.
Thank you, Ms. Fritz, for that
Appreciate hearing from Ms. Freeze.
clarification. And thank you, Senator, for walking us through and getting us ready for when we work the bill. And Ms. Fritz, thank you. We're going to go to Ms. Freeze. Julie, welcome this morning. Always good to see you.
Morning. Thank you for having us this morning. So the only thing I would add to the amendments that are going on is I'm still having a little bit of heartburn with us concurrently filing it on the title. So the customer has 60 days to pay their sales tax. It's generally sitting in our file. If I'm understanding what we're doing with the delivery date being the date that I guess the perfection happens, then why does it matter when I put it on the title? I can't do that now with the titling and UCC program that I have. I just can't put them on concurrently, and I don't have enough staff to put it on concurrently. Concurrently means to me I file it and then have to turn right around and put it on the title. So I was wondering if we could just have that a notation, and I don't know, my page might not be accurate, but page 2, line 9, which is the little II, a notation, and I just wondered if we could change that. A notation of the delivery date of the security agreement must be endorsed on the certificate of title to the vehicle or motor vehicle, and just put a period and delete the rest of all of that. So it's going to happen. It's going to be put on the title, but why do I have to do it concurrently? So I'm just wondering if we can drop the concurrent language.
So, committee, any questions for Clerk Freeze this morning?
Mr. Chairman, I'll be interested in how the rest of the speakers resolve that, and I don't really have an opinion. You also have Ms. Allen from the automobile dealers would like to testify.
We do, and we do have a couple more folks to testify. Julie, any final thoughts this morning before we go on to a couple other folks? I am kind of curious. You mentioned that this can be a little bit of a driver in terms of hidden cost on your staff. That gave me a little bit of heartburn. Are we doing above and beyond what we would normally do in 2 steps? We're kind of doing in 1, I thought, but can you expound a little bit?
So my point is, and I know Scott did come to our office so I could show him. So when we receive sometimes huge packets of, 20, 30 titles, and maybe I have 5 or 6 entities that do that to us, and I need to file them. So if I got it today, this is the way I understand that it's to be done right now. So if I got 5 packets today with 20 in there, we have to put those on according to this new law. I have to get those put on because I delivered it today. I got it delivered today. Now, if and that's the way my system works. So I put it in, has to have that date on it. But if I also have to put that concurrently on the title, the notation just on the title, that I can't do that now. I'm getting them filed on time, and I think that's where perfection is. And somebody in the banking world is gonna have to tell me if that's true or not, is once I file it, is that the perfection? And so if I don't have to concurrently, when I can get to the titles, and again, our customers have 60 days to pay their sales tax, it's sitting in my file anyway, can I not get that on there when because it's still gonna have the delivery date. So if I filed it today, let's say I had $21,000 for a lien and it was filed today, whether I do it 3 weeks from now or tomorrow. So I'm trying to take the concurrently out there so it doesn't hamper my staff, because I'm not doing it right now. I'm gonna be honest with you. Even when I have a full staff, which has been extremely difficult this year to have full staff all the time with COVID and elections and everything else. So that's just my question is, can we do away with making that a double whammy all at once, which is currently what the law is telling us to do, but I'm not meeting it, that part of it.
Clerk Priest, thank you. Really appreciate you bringing that to light, and we'll work that a little bit.
Thank you.
Thank you. I'm going to go ahead. Ms. Fritz, if we need you, we'll come back to you, okay? I want to move on to Ms. Gonzalez from just over the hill in Albany County.
Thank you.
Good morning, Jackie. Good to have you here this morning.
Good morning, Mr. Chairman. Thank you for the opportunity. At this time, I believe what has been mentioned by my colleagues, Clerk Fritz and Clerk Freeze, are the same concerns or testimony that I would offer at this time. I do want to reiterate how nice it is to be able to work with all of the associations to make this legislation work for all of us. I have no further comments at this time. Thank you.
Okay, Clerk Gonzalez, thank you very much. Committee, anything for Laramie? Okay, we're going to go to Miss Allen. Okay, good morning, Marcia. It's nice to have you here this morning.
Good morning, Mr. Chairman. Thank you for the opportunity to speak again. Marcia Allen with Wyoming Automobile Dealers Association. A lot of our testimony would echo what you've already heard from previous speakers. We appreciate the opportunity to work with everybody and try and work out the issue. We think that the proposed amendments, generally speaking, if the lenders are confident that it will resolve the issue, by extension, it should also provide relief to our members. As far as the new proposed amendments, we obviously haven't digested those or talked to our members about them, so I don't know how they would play in. But again, if the lenders are happy with the resolution, then it should fall to us. I know at the last meeting, some committee members expressed an interest in hearing from some of the dealers themselves. So in response, I did ask some of them. They all declined in providing public testimony. They were not comfortable with that, but they did indicate that they were willing to discuss individually with their local legislators any of the concerns or questions that they may have. The last thing I would say, I would just be remiss in saying that there are a couple who, through their growing personal frustrations within their county, may have some different ideas on how to address issues, and they may independently speak up. So if you hear from them, that we know that they are very frustrated. There's a couple of them, and they very well may speak up. And generally, I would just stand for questions of the committee if they have any.
So Ms. Allen, when you say that we have some dealers who are frustrated out there, are they frustrated that we're advancing a bill like this? Are they frustrated that it doesn't go far enough? Can you characterize what's going on with a couple of the dealers out there?
Mr. Chairman, the couple of dealers, I think it's their own issue there, and there may be multiple issues that they are having with their county clerk individually. Generally, I mean, they're not issues across the board in every county with every single clerk. You know, I think it's an individual issue with that particular dealership. So it's not tied to this bill in particular. It's a combination of a lot of things.
Okay, thank you. Appreciate that. Committee, any questions for the Automobile Dealers Association? Anything, committee? Okay, Ms. Allen, thank you very much. Appreciate that. That is all I have, Mr. Co-Chairman. No others on the list, but I always, given the Zoom platform and all the things that we have to do on these hybrid type meetings, I want to make sure that we allow anybody else for public comment who may have snuck in late in the game. So,
Mr. Chairman, I think Mr. Meyer would like to speak.
I'm absolutely willing to go back to Mr. Meyer. Mr. Meyer, rebuttal.
Thank you, Your Honor. Sorry, Senator Nethercott.
I should have a black robe on, I think. But anyway, go ahead.
I think that the issue that Clerk Freese brought up are addressed in the modifications that Representative Stith had put in there, because I think, and I won't speak for Representative Stith, but I will tell you that I'm looking at the changes that he had proposed. We're talking about getting rid of Romanet 2 and replacing it with B, and taking out that language of concurrently file with the filing, and putting in some language in there that shall note on the face. And so it does, that concurrency is not in there. And I think that addresses that question. So
that's helpful, Mr. Meyer. Thank you for that. Any final questions for Mr. Meyer? Okay, committee, we're gonna close public testimony and work the bill. What is your pleasure on this bill?
Do pass.
Move do pass by Senator Case, seconded by Representative Ayer. Discussion.
Mr. Chairman,
Amendments. Senator Case.
there is an amendment, and I wonder if Mr. Hewitt has the amendment and would like to walk us through it, or I'm willing to try to do that, but I bet he's better at it. So I'm just asking.
Mr. Hewitt, if you're willing to do that, that would be terrific. Please walk us through what has been discussed.
I may be putting him on the spot because I didn't hear back from him. So,
Mr. Chairman, I can walk through the amendment. So on page 2, line 1, and I apologize, I'm just gonna go through the amendment quite rigidly.
I might be able to better because I actually tracked it in, if you don't mind.
I tell you what, Mr. Hewitt, would you be willing to stand by just for
and correct me
and join in where the senator needs you, maybe? How about that? So
Sure thing, Mr. Chairman.
If you've got it tracked in, why don't you take
I'll give it a
off?
shot, Mr. Chairman.
Thank you. For
So
that.
here's the amendment. It starts on page 2, and after the line 1, the A, we delete the first line completely and instead insert perfection of A, and then it continues, security interest in a vehicle or motor vehicle required to be licensed as herein defined. We delete the colon and we say shall occur upon delivery to the county clerk in which the vehicle is located of 1, a financing statement or security agreement, semicolon, and 2, a properly tendered completed application for certificate of title. I'll read that again so that the entire little a will now read perfection of a security interest in a vehicle or motor vehicle required to be licensed as hereinafter defined shall occur upon delivery to the county clerk in which the vehicle is located of 1, a financing statement or security agreement, semicolon, and 2, a properly tendered completed application for certificate of title. Now, just to put a placeholder in there, Clerk Fritz suggested adding to that clause and most recent title of record. So we'll keep that in mind. They're continuing on the amendment. Lines 5, 6, and 7 are removed, deleted from the bill. Down to line 9, change the Romanet 2 to a B. And this will now read, we're actually going to keep the existing language and we're going to add a sentence after the paragraph. So the existing language would read, a notation of the security interest must be endorsed on the certificate of title to the vehicle or motor vehicle, comma, the endorsements to be made concurrently with the filing of the financing statement or security agreement, period. There's that word concurrently. I know we're going to talk about that. The clerk shall note, this is new language at the end of that, the clerk shall note on the face of the title the date that the security agreement or financing statement and completed application for title was properly tendered to the clerk, period. Again, noting Clerk Fritz's proposal, after the word title in those last few words, we would insert and most recent title of record. Then continuing, Mr. Chairman, we're almost got it. We go to page 3, line 12. Within the amended language, there's a clause that says the secured party delivers the financing statement. In between the words deliver and the, we'll make an insertion, and this is what it's going to be. The secured party delivers, insertion, a properly tendered complete application for a certificate of title and the financing statement or security agreement to the office of the county clerk. I'm finished the clause. And once again, that's the same location after the word title. that we would insert Clerk Fritz's language should we go down that road, which is to say, and most recent title of record. I think that's the amendment. How'd I do, Ted? I'm not looking for your job, that's for sure.
Well, a thumbs up is good. Committee, that is a substantial amendment. The Senator, I think, did a terrific job of walking us through what it does, but questions. Senator Scott.
Mr. Chairman, on the amendment on page 2, line 3, you've got two items that, do they both have to be tendered, or does just one of them have to show up? Is it an either or an and both of them?
Mr. Chairman, I'm going to maybe get Representative Stith involved if he's willing to jump in.
Representative, welcome back. Thank you for hanging in there as we work this bill. Can you provide an answer to the good senator?
Mr. Chairman, Senator Scott, yes, you would need both. But here's the purpose of why you need both. What we want to avoid is a situation where a car dealer throws a financing statement onto the desk of the county clerk and says on day 29 after delivering the vehicle and says, I'm done, but they don't bother to fill out an application for title, or they don't have some of the other information that the county clerk would need to make sure that everything is in proper order. So this would require both things to be delivered.
Senator Scott.
Mr. Chairman, I understand that now, and so it needs to be both. My question for Mr. Hewitt is, does the specific language provide that it's both of them, or could it be read the other way?
Mr. Chairman, Senator Scott, so the use of the and requires both. In interpreting Wyoming law, that and means it's got to be both.
Okay. Representative Murphy.
Thank you, Mr. Chairman. I have a question some of the attorneys can answer. It seems to me if the county clerk's accepting the security agreement or financing statement, it's not key to get that information on the title immediately. So as long as that's filed, that protects it in the bankruptcy courts. Am I right about that?
So Representative Stith, do you want to take a shot at that? And we've got our good attorney sitting here too, that we might allow Senator Nethercott to weigh in. So Representative.
Mr. Chairman, thank you. Representative Murphy. So the relevant portion of the bankruptcy code is 11 U.S.C. section 547 C3B, and that establishes a hard 30-day clock from time of possession to the customer to get the security interest perfected. Now, what's the jurisdiction of the states is that the state gets to decide when perfection occurs and what it takes for perfection to happen. So basically, with this amendment, what we're saying is that we're changing the definition of when perfection of the security interest occurs. And we're giving the banks essentially an extra 4 or 5 days by saying that so long as they've submitted their financing statement and their completed application for title and everything's in order, then they get the date of delivery. So that's why the state has the right to say when perfection occurs. So does that answer your question?
Thank you, Representative. Senator Nethercott, not to put you on the spot, but do you have anything to add that might clarify regarding Representative Murphy's question?
No, I just would like to point out, Mr. Chairman, the full geek out of Representative Stith today and referencing UCC comments, which is not a common occurrence in the law, and his pinpoint citation to the correct bankruptcy code statutory section. I mean, it's a bravo situation.
Yeah, here.
Call for the question.
Representative Murphy.
Thank you, Mr. Chairman. Well, I just want to clarify for the clerks. As they were pointing out, when they get a lot of these security agreements in, and if they're perfected, but it takes them a while to get this recorded on the titles. The point being, the banks are protected as long as the clerks are agreeing to the date of the security agreement and financing statement, so they can get that information on the titles a little later if necessary. I just wanted to clarify that. Thank you.
So Representative Murphy, if I understand correctly, and I appreciate you honing in on this, does that go to the concurrent language that is remaining in the amendment at this point? And you're saying that you don't think we need the concurrent, which was a concern by Clerk Freeze, right?
Thank you, Mr. Chairman. Well, that's what I'm trying to clarify. I think this amendment cleans that up, but I'm not certain about that.
Senator Nethercott.
Mr. Chairman, thank you. I think Mr. Meyer has a different take on the amendment, and it might be valuable to see. I think he's here with us, so perhaps he can enlighten us on that subject.
I noticed Ms. Fritz was willing to weigh in too, and stand by. Clerks, we may want to come to you. I think the committee really does want to work this into as good a form as we can. Mr. Meyer.
Thank you, Mr. Chairman. There has been a couple of different versions that went through there, but I think where everybody was in the last version that the Representative Stith had presented. And so what I would say and direct Mr. Hewitt to look at is, I think on paragraph A, it would say that, perfection of a security interest in a vehicle or motor vehicle required to be licensed as hereinafter defined shall occur upon delivery to the office of the county clerk in which the vehicle is located. One, and I will concede the word I will concede that to Representative Stith. One, a financing statement or security agreement, semicolon, and two, a properly tendered completed application for certificate of title. Then I think if we follow what Representative Stith had put in there, we delete the rest of Romanet 1 and we delete, I guess, the indentation where it says Romanet 2 and make it a small letter B. Then it would read, a notation of the security interest must be endorsed on the certificate of title to the vehicle or motor vehicle, comma, the endorsement to be made. And then I think we take out concurrently with the filing as of the time, all that stuff of the financing statement or security agreement. So the clerk shall note on the face of the title the date that the security agreement of the financing statement and completed application for title is properly tendered to the office of the county clerk. My point being in there is that we get rid of that. The sum and substance, I think, of Representative Stith's comments were, and as he had pointed out with the comments in the UCC, is that it has to be properly tendered. So that may answer the questions for Representative Murphy as well, is that what we're trying to do is make sure that, yes, we want to have a line on there that says when it is received. The clerks may take some time to get all their stuff done because, as Clerk Freeze just said, they might get 5 packets with 20 of them in there, each one of them, and you just can't really get everything done in one day. If they're properly tendered, then they just need to have that here's the date that it was received. They can still do whatever they need to do, and I don't want to hold them up on anything, but it would allow, I guess, that to be effective for that security interest to be on the date received if it is properly tendered. And I think that is the big key that I wanted to make sure that we had in there, that specific language in there, because it is really important, I think, to make sure that just because I drop a pile of doo-doo onto your desk and say, here, I've got it done on that 29th day. That is unfair and unrealistic to have a county clerk say, oh, well, let me go ahead and take care of that. I mean, really, if they didn't have anything else to do, they might. But the reality is that they're asked to be doing a lot of things, especially when I looked at all the stuff that Clerk Freeze had. They're asked to do a whole lot of grade school checking on this stuff to make sure that the people, whether it's the dealers or whether it's the lenders, have done all their stuff right. And it's embarrassing, I think, to look at that and see what kind of errors have been made. They shouldn't be held to any kind of a responsibility on the issue if they're not properly tendered. And so that's why I think that Representative Stiff's language in there is so crucial. And I'm happy to email this thing to Mr. Hewitt, what have you, but I just think that it's important that we get that in there and we don't have to worry about with concurrently filing and anything like that.
So I want to go to Clerk Fritz. You have stayed on with us. I appreciate that. Have you tracked what Mr. Meyer has stated this morning, Ms. Fritz? And are you comfortable that that alleviates some of the concern that we have among our clerks with that concurrent language? Is it a fix?
Thank you, Mr. Chairman and committee. I've been listening and kind of trying to go through it in my head here. The point being with the concurrent language, and Clerk Freeze may disagree with it, is that so the security agreement would be considered received or delivered, which would perfect it according to state statute if we remove that two-part perfection, which is what we're intending to do. However, we don't actually file it until we make the title. So that's why I didn't have any issue with concurrently filed with putting it on the, notating it on the title, because that's when we actually file it in our receiving book, is the same day that we would put it on the title. So I didn't have issue with that. We just needed to get rid of the two-part perfection law.
Okay, thank you. Questions of Ms. Fritz, committee? Senator Scott, did you have a question? I think, there you are. Go ahead.
Mr. Chairman, I've got a question on another part of the email.
Okay, thank you. Ms. Freeze, Ms. Gonzalez, does anybody else want to weigh in? Ms. Langford, any further thoughts there? I think you can tell the committee is interested in trying to strike this balance. So, okay. Okay, Senator Scott.
Let me try it. I asked staff to prepare it, but I don't think we got it.
Mr. Chairman, when the motion was made, as I heard, and I think I did hear correctly, the maker of the motion said on page 2, lines 5 through 7, that provision was be deleted from the bill. The effect of that is to leave in the law the language without the amendments that are shown. Was that what he intended, or did he intend to repeal lines 5 through 7?
Senator Case.
Mr. Chairman, I think that language stays in the law, but I'm going to yield to Representative Stiff. It's actually his amendment. Did you, and Clark, did you mean that that Romanet single I, would the old language would remain in the law? And that says a financing statement or security agreement must be filed in the office of the county clerk of the county in which the vehicle is located?
Representative Stiff.
Mr. Chairman, Senator Scott, Senator Case, the intention there, I think, is you delete lines 5 through 7 because they become superfluous once you have added the proposed new language on line 3 that says, perfection of a security interest in a motor vehicle shall occur upon delivery to the office of the county clerk in which the vehicle is located of a financing statement and a properly tendered completed application for certificate of title. So I don't think you need existing lines 5 through 7 once you add the new language.
So, Mr. Chairman, just to tie that up, and the good Senator Scott, he's we wouldn't be deleting this from the bill. We'd be striking the language. So we draw a line all the way through lines 5, 6, and 7. Thank you, Senator Scott. Good catch as always.
Go ahead, Senator Scott.
Mr. Chairman, that was what I suspicioned was going on. That's why I asked the question.
Okay, thank you very much. Appreciate that clarification. Committee, any other concerns, questions regarding the motion on the floor? Are we ready for the question?
Question.
Regarding the motion made by Senator Case, and I won't go through it all, it's substantial, but all those in favor, please raise your hand to the screen so I can see it.
Oops. I can't see my hand.
Sorry.
My hand's up. I can't see it on the screen. Waving.
All those opposed, anyone opposed to the motion? Okay, that motion has passed. Further amendments to LSO 0089. Further amendments. Mr. Hewitt, would you please take roll on LSO?
Mr. Chairman.
Senator Scott.
Mr. Chairman, I'm going to apologize here, but I've had internet troubles all morning and I was unable to hear some of the key early testimony. Rather than hold the committee up, Mr. Chairman, I asked to be excused from this vote because I understood the amendment all right. It was clear at that time, but it wasn't clear when they're talking about the need for the bill as a whole. So that's my request, Mr. Chairman, to be shown as excused on the current coming vote.
Thank you, Senator. Granted. Please make that note, Mr. Hewitt. Anything else, committee? Okay, we're going to go to roll call and then to lunch. Mr. Hewitt, roll call, please.
Senator Case.
Aye.
Senator Nethercott.
Aye.
Senator Schuler.
Aye.
Senator Scott is excused. Representative Blackburn.
Aye.
Representative Clausen.
Aye.
Representative Clem.
Aye.
Representative Clifford.
Excused.
Representative Duncan.
Aye.
Representative Ayer.
Aye.
Representative Furphy.
Aye.
Chairman Lindholm.
Aye.
Chairman Lambert.
Aye.
The motion is adopted.
Thank you, Mr. Hewitt. That bill is on its way to the session, whenever that session might be. Committee, we are a little bit past the normal lunch hour, but it is time for us to take a break for lunch. Let's do that until 1:30. Let's try to do that in an hour, okay? Let's come back at 1.
Mr. Chairman, please remind the YouTube land of a new link.
Thank you, Katie. I appreciate that. You will have to find the new link in the afternoon. We will set up a YouTube.